Hear. All persons having any business before the Honorable, the Justices of the Appeals Court, now sitting in Boston, will before the Commonwealth. Your name and retention shall be heard. Now see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Justice Peter Sachs. To my right, your left, is Justice Suk-Young Shin. To my left, your right, is Justice Andrew D'Angelo. Will be your panel for all 5 cases today. We have read your briefs. We know your arguments. We know the record. So I would encourage you to get right to the heart of your argument. We do expect to take a break after the first 3 cases this morning. So with that, I'll call the first case, 22P583, Commonwealth versus Ryder M. CHILCOFF. And it's Ms. Allen.
Yes, Your Honor. Good morning, Your Honors. May it please the Court, Ashley Allen for the defendant appellant, Mr. Ryder CHILCOFF. Now, I know you've heard this a million times, but this is not your typical rape case. There was no force, there was no threat of force, and it is undisputed that the complainant in this case did consent via words and actions. What is disputed is at the time of consent, whether this complainant was too intoxicated voluntarily to provide legal consent, and if so, whether the defendant either knew or whether he reasonably should have known that she was unable to provide the consent. So there are a number of issues on this appeal. Sufficiency of the evidence, whether or not certain evidence should have been allowed in, suppression of the statement, whether or not there should have been a mistake of fact instruction. And so unless this court has a preference, I would like to start with whether or not a mistake of fact instruction should have been provided to the jury. So mistake of fact, before I begin, we need to understand that this is in the light most favorable to the defendant. So if there's any reasonable interpretation of the evidence that would support a mistake of fact instruction, it should have been given. Here, and we understand—
Well, in Blaish, I think it was, the court talked about mistake of fact, but then prescribed, and I think it was later adopted, a sort of a model instruction that does not mention mistake of fact, but instead requires the Commonwealth to prove that the defendant knew or reasonably should have known of the lack of consent. Why doesn't that get the defendant everything that a mistake of fact instruction phrased that way would get the defendant?
Because it doesn't ever consider his state of mind. And so—
Well, it requires the Commonwealth to prove that he either knew of lack of consent or he reasonably should have known of lack of consent. So if he had a reasonable mistake of fact, the Commonwealth couldn't prove either of those things, correct?
I don't agree with that. I think that the jury could have found that he didn't know, but because that a reasonable person should have known. And here, I do believe that it's an objectively reasonable belief in that they could have found that she did provide consent with her own words and actions. Her friend and twin sister didn't know of how inebriated she is, that she was blacked out. Really, only she was the only person that knew about
Perhaps the jury could have found that, but they were instructed that to convict, the Commonwealth had to prove that the defendant reasonably should have known of lack of consent, and they convicted, so they must have found that.
Well, I think that it's slightly different in that if he held this belief, that it was honest and reasonable that he had this belief that she could consent.
Well, how could both be true at once, that he has a reasonable belief that she did consent and that the Commonwealth has proven he reasonably should have known she did not consent? I don't see how those two can coexist.
Well, I think I think the court in Kennedy has they considered that you do give that instruction. He knew or should have known, but there's still it's appropriate and fair defense in these cases in which you have to give that instruction, because it goes further to say and the instruction here was requested that if the defendant is not, this defendant is not guilty of this crime, if he actually and reasonably believed that the complainant was capable of consenting. So even if a reasonable person might have known, this defendant specifically believed that he was proceeding with valid consent.
So are you saying that in certain circumstances a victim could be just so intoxicated that everybody in the world knows she's drunk, but because she says to the defendant, "I consent," he can then use the defense, well, I thought she consented because she said so.
No, because I don't think it would be reasonable in those circumstances, because in those circumstances, you're getting closer to that wholly, like incapacitation, that this person is unconscious. In those cases, we don't have this concern about mistake because it's clear whether there be some indicia of non-consent or that it's so obvious on its face. Where this, I mean, she was navigating stairs, she was holding conversations, she was her closest friends, her twin sister didn't know.
I understand the facts, but I guess this is going back to Justice Sachs's question, which is, what is the difference between reasonably should have known, which is the instruction he got, and reasonably believed, which would be in the mistaken fact defense?
Well, I think it's this specific state of mind of this defendant. And so the jury was, even if they believed that he, in his heart of hearts, thought that this was, valid consent and that he was proceeding with that, they had to find him guilty because a reasonable person should have known.
What case says that a subjective belief about that the victim consents is a defense, notwithstanding that it's unreasonable?
There isn't a case. I think.
Do you contend that that's the law?
Well, Butler is the closest case to the facts here.
But just to be clear, do you argue that notwithstanding that the belief is unreasonable, if there is a subjective and good faith belief that the victim consents, that that's a defense?
No, and I don't think that the belief here was unreasonable. I think if you consider all the factors that the defendant provided and taking them in the light most favorable to him, that it was a reasonable mistake here, and his defense counsel at closing arguments argued for that. But unfortunately, there was no meat to that argument because they weren't provided with an instruction that said even if you believe that Mr. CHILCOFF thought that he had consent, you still have to convict because of this other knew or reasonably should have known. So it goes to his knowledge. It provides a state of mind that otherwise didn't exist.
But even as to the mistake offense jury instruction, even if he knew something or he believed something, that belief has to be reasonable under the case law, doesn't it?
Right, and it would be for the jury to decide once the judge determines that there is at least some amount of evidence that points to this. It would be for the jury to decide whether or not his specific belief was reasonable. And so I want to go back to the Butler case because it is so closely aligned. And in there they said that there was a subjective belief, but as a matter of law, it could not be a reasonable belief because it was a police officer with somebody who was in protective custody. And by definition, protective custody is incapacitation. There's also the law about correctional officers, and you can't provide consent when it's somebody who's a subordinate to you. So in that argument, and I know that it's not in the case itself, but in the oral argument, the Commonwealth stood up and said that this is the best case for when this instruction should have been given, other than the fact that it was a police officer. And I think here we're even closer to that. And so I don't argue that this is something that happens all the time. I mean, there's a very, very narrow line of cases that this would be applicable. And that's where the Commonwealth is proceeding on a theory that of incapacitation. There's no threat of force, there's no indicia of non-consent. And we have all the facts here that weren't present in Butler, and the reason why this court said you're not entitled to the mistake of fact instruction. But it boils down to the SJC has consistently said over and over again that we are keeping this possibility open, that to prevent injustice in these sort of cases, and what Justice Spina had feared in the Blage case, is that there are going to be people that are wrongfully convicted because they have intercourse with somebody who is under the influence to some degree, and they didn't know how drunk they were. And the law doesn't require, or the law does require, that we have we know what we're doing. So here, this was sort of a gray area, and that's not what the law requires. And Mr. CHILCOFF proceeded on the belief that she did consent, which she did, and that consent was valid. And so I would suggest that it was appropriate for the mistake of fact instruction to be given, for the jury to be able to consider whether or not he had that reasonable belief. And so moving on to the sufficiency argument, I think that this is now the opposite. It is in the light most favorable to the Commonwealth, but here they didn't present enough evidence beyond a reasonable doubt that this person was incapacitated to the degree of extreme intoxication. It's a high one, the standard of incapacity, and intoxication by itself does not necessarily mean that someone's unable to consent. And put simply, she was capable because she did. She was able to make decisions throughout the night. She decided that knew where she lived. She knew where she was walking home to. She was able to navigate the security doors and go through security, the elevators, the stairs. And she did, even...
She was able to find her way to the wrong room.
So I do want to address that. So the Commonwealth says that that's what happened. Now, there's conflicting evidence about that. The main witness on this case was Mr. David Lewis, who was the roommate of Mr. CHILCOFF. He's the one that testified as to seeing the consent, and he wasn't exactly a good witness for Mr. CHILCOFF. He wasn't sugarcoating anything. He said what he said. And he said that at the very beginning, he went downstairs and looked around the room, the floor, because she said she was partying with her friends down there. Didn't find any friends, but found a room with her name on the door. So when he went back upstairs, he said, "Do you live right downstairs?" And she said, "Yeah," and said 1614. So it was acknowledged at that point that she knew that she wasn't in her own room. She never objected to 3 strange men watching Star Wars in her room or anything of that nature. She understood that was her room. They told her to go back down to it, and she says, "No, I'm staying here." This is not something that they shut the door behind her and they made her stay. I mean, she was there on her own volition. They tried getting her to leave. She didn't want to leave. And then later in the night is when, after an hour or so, 2 hours, that this intercourse occurs. And so arguably she's sobering up as the night goes on. And the last time that she had consumed alcohol was much earlier in the night. There's no evidence whatsoever that she consumed any alcohol after midnight. And it's arguably even before 11 o'clock at night. So we have 3 to 4 hours later that she's now consenting to having sex, and she's the one that initiated the intercourse, grabbed my client's hands, put them on her own body, said, "I want you." He asked an open-ended question, "What do you want to do?" This was not something where he came on to her. And so here, I think that there was an argument that she thought she was not in her own room, but I think that it was more so that because her room was directly below, the Commonwealth argued that was the circumstance.
Since there's an argument that she went to the wrong room, when we're looking at sufficiency, it's in a light most favorable to the Commonwealth, correct?
But the testimony was that she knew that she wasn't in her own room. So while they may have inferred that she maybe thought that she was in her own room, and she doesn't remember anything. So really, I mean, we're relying on these witnesses who were there and weren't blacked out drunk, and not anything that she actually believed. So we're really trying to draw this belief of hers, her state of mind, from somebody who has no memory of anything. And so I understand that the Lattimore standard, it's not in my favor. But when it comes to the cases in which they have found that it was sufficient incapacity, you have somebody who's falling down drunk, they're face down in the dirt, they can't...
Well, in the Commonwealth's, in a light most favorable to the Commonwealth, the testimony as she's walking to the apartment house, I'll call it, the apartment building, she was falling down drunk. Again, I know from your perspective, and there's different evidence, but from the light most favorable to the Commonwealth, one of the witnesses testified, I think it was a he, that he had to help hold her up.
So I will agree that there is testimony that she was wobbly, she was stumbling, she never once fell. And there's a whole bunch of, another unique portion of this case is that UMass is covered by security cameras. So there's cell phone video evidence as well as security camera evidence that shows her walking without assistance, going down the stairs while running and laughing and joking with that male who testified to that. And there is, nobody is disputing that she had some sort of degree of inebriation. And I think that even when you look at the drunk driving cases and that sort of stuff, just because somebody's stumbling doesn't mean that they're unable to make these decisions. And we're looking at a very high standard of incapacity. And here, I don't think that the Commonwealth met that in comparison to the cases in which you have somebody who cannot physically or even with their words not consent to sex. And so it's opposite of those unable to act cases like Jansen and Morin. And even, from her own mouth the next day, she texted her twin sister and said, "I didn't even drink that much." So even though she was blacked out, that is not indicative of how drunk she was. I mean, that is something that is personal, and the expert testified to that just because somebody is blacked out, that is not an indicator of how drunk they are. If there's no further questions on that, I would just like to briefly go to the rape shield issue. So here, I just want to point out that the Commonwealth had, in the amended brief, the Commonwealth had said that this was never raised below. It was raised in the motion in limine, and the defense attorney did argue that one of the exceptions of the rape shield statute is that you can admit this sort of evidence to explain some sort of condition, physical attribution of the complainant. Well, she testified that, well, I knew that I had intercourse against my will because I had an odd sensation down there, I had chest pains, and she was talking about the physical aspects of that. So that was another reason as to why they should have allowed evidence as to whether or not she had sexual intercourse with somebody else that night, same level, more drunk than when she would have had sex at 2 o'clock in the morning. And at that point, the jury would have been able to consider too whether there was another person who had a reasonable belief that this person could consent to sexual intercourse. And I see that my time is up, so I would rest on my brief and
Thank you.
thank you.
Ms. Lynch.
Good morning, Your Honors. May it please the Court, Bethany Lynch, Assistant District Attorney representing the Commonwealth. If the Court is amenable to this, I will follow the same arguments that my sister raised in that order, unless the Court has other questions and would like to direct me elsewhere. The issue of the mistake of fact instruction, it was raised below. The defense attorney asked for it, but I would suggest to this Court that the trial judge did not err in denying that instruction. Based on the state of the case law that the trial judge was looking at, he did not find that this case met a mistake of fact instruction standard.
Can you envision a circumstance where it would, in this similar situation where it's basically intoxication and somebody who is the alleged victim says, yes, I want to have sex?
I think if her level of intoxication was significantly less, if it wasn't so, from the Commonwealth's perspective, and as the jury likely found, blatantly obvious that she was incapacitated, it would have, if it was someone who had a couple of drinks and then thereafter, and there was evidence that she had a very minimal amount of ingestion of alcohol, in a situation like that, I suppose it could be. I think that the SJC left the door open to see what kind of cases that may come up in the future. I can't really envision a case where a mistake of fact instruction would be required, because I would suggest that the instruction as given covers that, it encompasses that situation. Because a mistake of fact instruction is generally given where that mistake would negate the existence of the mental state required for an essential material element of the crime. And in this case, that mental state is explained to the jury. The mental state that they must find is explained to the jury by the knew or should have known that she was incapacitated. And I would suggest that that covers that. There's no, and the courts have said, the SJC has said in Kennedy, in Lopez, in Blatch, and in Butler, in all of them that, I believe in Butler, that mistake of fact as to consent in a non-incapacity situation is not an appropriate instruction to give. And where there is an issue of consent due to incapacity, I would suggest that the instruction in Blatch, which was given nearly verbatim in this case, would cover the issue where the defendant, I would say that there is no evidence, there's no reasonable evidence for this defendant to believe that the victim was able and not incapacitated. That's a backward sentence, I know that. It didn't come out the way I had it in my head. But in this case, because he reasonably if the Commonwealth proved to the jury that he either knew or should have known, then evidence that he reasonably should have known, then evidence that he reasonably didn't know would not have been credited by the jury. I would suggest, are mutually exclusive, and so the instruction as given incorporated any kind of evidence of the defendant's claims that he did not realize her level of intoxication. So I would suggest that there was no error in this case because and the other thing is that in order to get a mistake of fact instruction, there would have had to have been reasonable evidence that she was not as intoxicated or incapable of consent as she was. And I would suggest that the only evidence that we have, again, if it is in the light most favorable to the defense, is that he said he didn't think that. And that is an objective standard, but a subjective standard, but it does not cover the objective should have known.
Well, from the defendant's perspective, according to the statement that he gave to the police, the victim was speaking coherently to him. He asks her a question. She coherently gives him an answer. Mm-hmm. Also, from the defendant's perspective, his friend is there, and his friend doesn't call the police, doesn't tell him you shouldn't. I mean, I know from your perspective that maybe he gave a hint.
The friend did tell him that this is a very gray area. She is intoxicated. Just because she said that, you shouldn't do it. Would you like me to get to the resident assistant at the dorm? And the defendant said no. And the defendant then asked his roommate to leave. So I agreeing that is what the defendant himself said, but I would say that is actually contradicted in part by his roommate, and that...
But it's in a light most favorable to the defense whether the instruction should have been given. So no matter what the friend says, if we adopt what the defendant said to the police, which was admitted, he should get the instruction.
Well, I would suggest that he is entitled to the instruction that he got, and that goes to the whether he knew or should have known. And
could we find that the mistake of fact instruction should have been given, but it was harmless error?
Absolutely. Absolutely, you can find that. Without conceding that it should have been given, absolutely, because, again, between the evidence, the strength of the evidence in the case, and the fact that he did receive the proper instruction that he either knew or should have known, and the jury knew that they had to find one of those two elements beyond a reasonable doubt, then he absolutely would not have suffered any prejudice in this case because the instructions were proper as given, and the absence of an additional, almost a reiteration of a part of an instruction did not cause him such prejudicial error as to warrant a new trial in this case. Unless there are further questions on the mistake of fact argument or issue, I'll move on to the sufficiency of the evidence. I would suggest to the court that, knowing the Lattimore standard is in the light most favorable to the Commonwealth, there was more than adequate evidence in this case, limiting ourselves at this point for our review here to the issue of incapacity, because the defendant doesn't challenge any of the other elements of the rape charge. But as to the incapacity of this victim.
Well, I'm sorry to interrupt
That's
there.
okay.
If we adopt the defendant's argument that the statement should have been suppressed, what evidence would there have been that there was any intercourse whatsoever?
I would say that the intercourse would have been proven by the victim's own statements, her sensations after the fact that she woke up in a bed without her underpants or her pants on, that I mean, in terms of penetration, I think that the fact that she had certain sensations in her vaginal area, I think that would be enough to know that some sort of penetration happened at that evening, even without the defendant's admission of penetration.
Wasn't there DNA evidence from the condom?
Oh, yes, there was that as well, sorry. that would have been the lead. Yes, there was DNA on the condom that was found in the defendant's dorm room after the fact as well. And that obviously would also lend itself to the belief that intercourse had occurred that night. But in terms of the sufficiency of her incapacity, from the statements of all of the witnesses, we know that she drank between 5 and 6 shots of vodka. She also drank an extensive amount of beer after the fact. at her pregame party. When she left, she was stumbling at that point. Her friends, her sister all noted that. When she then went to the frat party. We don't know what she drank there because she doesn't have a memory, but we know that 3, I'll call them Good Samaritans, did find her outside a party in December and alone and unable to use her own cell phone. So they recognized in her a person who was too intoxicated to be left alone. They offered her help. They walked her home. She was, I wouldn't say incoherent, but she was not following conversations. She was stumbling around, and they saw her to her dorm. And at that point, yes, she was able to walk up the stairs, but she did go to a room of someone she had no idea who that was. And I would suggest that the evidence does support the fact that she believed it was her own room. And I have citations, and I forgot to write the volume down, but they are cited in my brief, testimony by David Lewis that she implied that she believed she was in her own room. The rooms were set up the same way. She went to the bed that would have been hers if she was in the room in the back half. She undressed. They kept saying, "You've got to leave and go to your," no, I'm staying. This is, she implying that this is her room. She then, she fell sound asleep for a period of time. The occupants in the room, when she came in, they recognized that she was unsteady. One of them, Kowalczyk, who was the friend who was visiting, he noted and said, "Wow, that girl is drunk," and thought it was very early in the evening. I want to say that she checked into the dorm at approximately 12 a.m. And by 2 a.m., sometime in those hour and a half to hour and 45 minutes, she made her way around the dorm and went to the defendant's room once, was highly intoxicated, noted by everyone there, left, and then came back and just walked right by them and went and got into bed. And I would suggest that that would be obviously evidence of an incapacity. She also her condition was such that the roommate wanted her out of the room badly because he was afraid she was so intoxicated she would vomit in the room. He wanted her out. She fell asleep. At one point, yes, the one friend left. It's the 2 roommates. The defendant and his roommate are in the room, and the defendant is standing next to the bed, and she, now having removed her own shirt and gotten into bed and fallen asleep, she then wakes up and makes sort of groggy pass at the defendant. And the roommate says, "This is a gray area. You should not do this."
What evidence is that she was groggy?
I think just that she's waking up and she's moving.
There was no evidence that she was groggy. The evidence was she wakes up, she has her clothes off, she grabs the defendant's hands, she starts rubbing his hands on her body, and that's when he says to her basically, "What is it you want to do?" And there's no evidence that she was groggy.
I think I was inferring it from the fact that she was in and out of waking up throughout the evening. So I was just inferring that. But yes, there's absolutely no direct evidence that she was groggy. She did do the things that you've noted. But the roommate says, "You should not do this." Just because she's saying it doesn't make it right. And the defendant says, "I don't want you to call the resident assistant to help us get her out of here, get her back to her room," because by then they knew her room, or they suspected her room was one directly below. And I suggested that is a reasonable inference, that she was just in the wrong room. The dorms look the same. The elevator system, if you read the briefs, I tried to explain it, where the elevator doesn't go to her floor. You have to go up or down. And so I would suggest that she did reasonably believe that she was in her own room in her state. And the defendant declined assistance from a resident assistant and told his roommate to leave and go to the common room, where he did stay. The roommate did leave. And so I would suggest that all of those things together show not only that he knew that she was highly intoxicated and incapable of consent, or should have known, but also that he also intended to take advantage of that by sending his roommate out and declining any assistance from a resident assistant. And I think, sort of in a thumbnail, in this situation, an unknown drunk girl walks into his room, says it's her room, or implies it's her room, gets into bed, undresses, and falls asleep. I think those are very good indicators that this girl's not making rational decisions at this point and is not capable of making those decisions.
Counsel, I see your time is running low.
Certainly.
I wanted to move to the DNA and underwear issue.
Sure. I think
the Commonwealth introduced the fact, and you just talked about it earlier in your argument, about the physical sensation she was feeling. doesn't that open the door to the defense offering a counter-explanation to that that doesn't interfere with the rape shield?
I think in some situation it might. In this situation, it can't. Because in this situation, the DNA that they sought to introduce was a sperm fraction of an unknown individual on a pair of underpants that she was not wearing that night.
Well, that's the part I'm glad we got to so quickly.
Yes.
How do we know that? Because no one asked her about that on the witness stand at trial or in any pretrial evidentiary hearing.
We do know from the defendant that he described her underwear as green. I believe that we know that from, perhaps it's from the police report. I know that there's no indication of it in the trial, but it may have been in the pretrial, in the police reports, where the issue of the color of her underwear, and the defendant says her underwear was dark green. And he claims he tried to return it because he still had it, and she left without it. She left the room, and both the complainant and the roommate say she left without her underwear.
Then there's also evidence that the defendant put a pair of underwear, and again, this would again be in a light most favorable to the defense on this. He puts underwear in a bag, puts it to her door. At some point after that, she goes to the hospital, and they collect it.
They collect the underwear she's wearing when she went to the Seine.
Why would they collect evidence of underwear that had absolutely nothing to do with it?
That I cannot say, except that I believe that as part of the Seine process.
We don't know if it's the underwear she was wearing at the time of the exam, right? I mean, so I'm looking at the evidence form from the kit, and it says underwear worn at time of assault, and the box if not indicated is checked. And then it just says underwear worn after assault, and it's the yes box is checked. So we don't know what after the assault necessarily means, right?
That's correct. I mean, it's my understanding that it was the underwear she wore to the Seine exam, and that's the underwear that they collected because it was within a couple of days. So they collected that. But I think that the key here is that I see.
Finish your key, and then I have a question.
Okay, I think that the key here is that unless we know that that the underwear with DNA on it is the underwear she was wearing the night of the incident, it doesn't have any relevance whatsoever to this case, to whether if she had had sex at some time prior or at some time after. Long before, long after, because this is different underwear. If it was that same night, if we had sperm or a sperm fraction on underwear that we knew she was wearing that night, which the defendant himself contradicts, then possibly that might open the door. But in this case, there was no evidence to support that, and so the trial judge pre-trial in the motion in limine to admit it properly denied the motion to admit the DNA evidence.
So my question is whether because this was the defendant's motion in limine to admit, or because of the rape shield statute, or both. Was it the defendant's burden to show relevance?
Yes.
And what case says that?
I believe the statute suggests that. I believe that the rape shield statute precludes evidence of a victim's sexual activity unless the defendant can overcome the burden to show both relevance and probative value that outweighs the prejudice to the defendant.
Thank you.
Thank you very much, Your Honor.
No further questions here. All right, our next case will be 22P113, Commonwealth versus Samuel Ward. Ms. Paradise, whenever you're ready.
Thank you. Good morning, members of the panel. May it please the court, my name is Emily Paradise, and I'm here today on behalf of the child. At its core, this case raises the issue of whether the 16-year-old child's waiver of his right to a jury trial could have been knowing, voluntary, and intelligent, where the trial judge failed to read the critical constitutional rights as part of the colloquy and where trial counsel provided ineffective assistance of counsel in failing to advise the child that essential Commonwealth witnesses had a likely Fifth Amendment claim, and where he also failed to advise the child that what he was agreeing to that day could lead to additional punishment subsequently. I am asking this court to find that the trial court made a significant error in finding that the child's waiver was voluntary due to the combination of the court's errors and trial counsel's errors, and that, moreover, the trial court erred in denying the child an evidentiary hearing on this matter. This morning,
So why couldn't the judge credit counsel's representation as to his general practice? This is with regard to the potential Fifth Amendment issue. Why couldn't the judge credit counsel's representation as to his general practice of discussing with clients what evidence would and would not be available and to be introduced at trial? And why couldn't the trial judge or the plea judge decline to credit the juvenile's representation that no discussion of that ever occurred?
well, and I think this does bear on the denial of an evidentiary hearing. Why couldn't he credit it? He could credit it. One, the extent of the conversation was there was a question, a very specific question posed to trial counsel saying, what conversations, if any, with regard to the privilege against self-incrimination did you have with regard to the essential witnesses? So he's saying, this is my general practice. As a general practice, well, first of all, he said, I don't actually remember the conversation, but as a general practice, I discuss what evidence will and will not get in, and I discuss the Bruton rule. But that's not a specific answer.
Right. It's not directed to the particular Fifth Amendment. But even without that affidavit or the representations attached to appellate counsel's affidavit, why couldn't the plea judge just decline to credit the juvenile's representation that no such discussion occurred?
Well, I think it's a mistake to not credit the juvenile's sworn statement when there is absolutely nothing on the other side opposing it. Had trial counsel, I mean, again, I'm sure the court has read all the correspondence where I tried to determine this. Had trial counsel say, I have a checklist. In every case I meet with the defendant before they offer a plea, I say, just so you know, and the CPCS standards require this, just so you know, before you go in and take that plea, you need to understand, you know, that you've got witnesses who may or may not testify. If he had given a specific list of what he goes through, but general practice is quite broad, and the truth is your general practice can be fine, but if in a particular instance you fail to advise the child of what I would consider sort of a central issue in the case. I mean, you got two witnesses who can ID him, one's the go-between, one's the drug dealer. For anyone who has practiced in district court, this is sort of the classic Fifth Amendment situation.
Well, let's talk about that. Let's assume that there was no such discussion, but you still got to show prejudice on the ineffective assistance. Why isn't it quite speculative to think that these witnesses who told the police what happened, or at least their version, which was pretty incriminating for them, and told the grand jury what happened, and even the victim who was beaten with the gun even showed up at the plea hearing to say this guy should be punished for what he did. So why isn't it speculative to think that if they already told their stories at least twice, once under oath, why would they suddenly assert a fifth at trial?
Well, I think because easily the way it could have gone at trial, and again, the court has the cites, the fact that they testified at grand jury doesn't mean that they would have testified at trial. But
sure,
I think
they don't have to testify. It's not a waiver at trial, but why would they?
But the standard is, was counsel's advice not within the sort of ordinary fallible, and would it have made a difference? Would the child have elected to go to trial had he been advised of the fifth? And any number, so would he have elected to go to trial? What the trial court had before is the affidavit saying he would have elected to go to trial because, of course he would.
Well, but his affidavit says, if I'd been told that if the witnesses took the fifth, then the Commonwealth couldn't prove his case, then I would have gone to trial. But there's no discussion in the juvenile's affidavit of the likelihood that those two witnesses would take the fifth. So in any rational decision-making process about whether to accept the plea, doesn't the juvenile have to consider not only the possibility that those witnesses might invoke, but the likelihood?
I don't think the burden is on the juvenile, the child.
To show prejudice. To show prejudice, the burden is.
It is to show prejudice, but this is, if trial counsel had said to the child, let's set this up for trial, it can go one of two ways. Either they will show up, this is what would have happened, right? The trial counsel would have brought it to trial that day. Competent trial counsel would have gone before the judge and said, Your Honor, one's a go-between, one's a seller. I'm going to ask that you appoint counsel. Counsel would have been appointed to advise them on their fifth, and likely would, again, we don't know that, but all we have to do is get to the stage where the child would have made a different decision and would have, I think under Hill and Lockhart, if it's, I think that's the right case, if it is a plea, would he have elected to go to trial? And prior to entering a plea, he would have elected to set it up for trial. What happened on the trial date, I don't think we know, but I don't think he has to show that. What he has to show is that he was not, one is, I mean, I have no idea which is likelier. All he has to show is that if trial counsel had told me that they might claim a fifth, I would have set it up for trial, and maybe they wouldn't have showed, and maybe they would have
But if they do show, then he's facing a 20-year mandatory minimum. Would that be a rational decision?
I would say that people set things up, I mean, just because he gets offered a plea on Tuesday does not mean it won't be available the following Tuesday. People routinely in district court set things up for trial. Let's see if the victim shows up. Set things up for trial all the time, and then on the trial date, if they show up and they decide that they're going to decline and they're going to get on the stand and testify that they were selling drugs, yeah, we knew to call him because he's always got marijuana, then there is nothing in the record to indicate that he would not have had the benefit of that same agreed-upon plea, which it sounds like trial counsel and Commonwealth had worked hard to come, because the court said, if this weren't agreed, well, he did ultimately.
So when does this Martin hearing occur? When would it occur relative to the commencement of trial?
I think it would have commenced on the trial date if there were one. I think it's possible that there wouldn't be one, that the counsel appointed to advise on the fifth would merely say, Your Honor, I mean, the essence of the conversation would be what they were doing, and that would be the end of the case, but otherwise the court could inquire on that date.
So the trial begins, the Martin hearing is held, the victim and the go-between say, yeah, we want to testify. Is there any evidence that the defendant can then say, okay, I'm ready to plead, and that the Commonwealth still would have gone for it?
I don't know. There's no evidence of that, but
So if there's no evidence of it, and there's no reason to assume it, is there? I mean, isn't the burden, again, on the defendant, or the juvenile, to show prejudice?
But I think the court is looking at a different standard for prejudice than the child views it as. I think what you have to show, what the child has to show is, would I have made a different decision? I mean, but the CPCS standards say, before you advise a child on a plea, make sure the witnesses are available, make sure the Commonwealth has everybody there. I mean, I don't think that it's on the child to prove, I mean, obviously that is speculation. What would have happened on the day of trial had counsel advised me and I set it up for trial? There's no way you can get past speculation there because it didn't happen. But I think that's not what the child is required to show. All the child
is required to show that the counsel's defective advice led to deprive the child of an otherwise available substantial ground of defense.
Right. Right, and that perhaps if they had not shown up on the trial date or taken the fifth, he would have had a dismissal.
That isn't, as the plea judge said, the motion judge, isn't it speculative? That, and therefore not substantial ground of defense.
With all due respect, Your Honor, I think I think the inquiry stops at an earlier spot, which is no one is required to show what would have happened on the day of trial because one can't know. But I think this is what we know. We know that from correspondence that trial counsel had correspondence that he kept. He had letters, he had communications which he did not provide to me. I think that was the reason to have an evidentiary hearing because have an discretionary to hold an evidentiary hearing, but if there's a substantial issue raised. Is it a serious issue? Yes, it's a serious issue. Had the Fifth Amendment been raised and the witnesses had not testified, the Commonwealth could not have gone forward.
That in and of itself, that statement is speculative as well. If they asserted a fifth, they testified at the grand jury, that could have been testimony by an unavailable witness.
I think they would have to prove.
I know that's speculative too, but it could be.
It depends upon the reason, right? But I don't think the failure to appear in response to a summons is sufficient for unavailability.
No, but if they take the fifth, that's an unavailable witness. They've testified before the grand jury. It's a testimony in front of the grand jury that inculpates the defendant and does not exculpate him. It potentially, and I think that's what we're looking at, it potentially could still have been admissible. So it's all speculative.
Then I think that's speculation. But the truth is then that would make the fact that testifying at the grand jury doesn't, I mean, you can not claim that, you can testify before the grand jury and then not claim the fifth. Then there's no, that sort of undermines the whole protection that you have that if you testify before the grand jury, you can still claim the fifth at trial. Otherwise, no one would ever need individuals to testify at trial.
That's because it's protecting the person who makes the statement, not your client. They can still assert a fifth and therefore not be used against them. But that doesn't mean that it can't be used against your client. And that's the perspective I'm having, which is showing prejudice. Everything you're saying is if they claim the fifth. We don't know whether they claim the fifth. There's nothing in the record of an investigator speaking to them saying they're going to claim the fifth, and everything to the contrary exists. They gave a statement to the police, and they testified before the grand jury.
And this is where I would say then that's the error in not holding an evidentiary hearing, because there was one way. I mean, again, the court's familiar with the correspondence. I tried to get answers to this. The reason I requested an evidentiary hearing is because what we have is a very clear statement that says, I would have set it up for trial had anyone mentioned the fifth to me. That seems to me quite clear evidence. What we have on the other side is, I don't remember any conversations.
Where the defendant, the juvenile, doesn't say in his affidavit, and I would have considered the likelihood or not that they would have taken the fifth. His affidavit doesn't seem particularly rational and therefore credible.
I thought it did seem rational. What he had said specifically, I believe, and again, I am not reading the exact words at this moment, but I'm quite familiar with it. Had he been advised that the witnesses might take the
possibility,
fifth,
right,
that he would have elected to set it up for trial. To me, that's the end of the inquiry. Would you have elected to set it up for trial? Not what you would have done on the day of trial, not what they would have done. He doesn't have to spell it all out. But trial counsel, I actually think, does have to spell it out. What we've got is, he never advised me on the fifth. I don't remember any conversations. It's my general practice to discuss what evidence will or will not get in. I mean, I guess as a subset of that, what will or will not get in is whether people take the fifth. But it was such a specific question. It's not like the fifth is such an esoteric principle that we should have to interpret within that what evidence will and will not get in means. It was so easy to say in response to a specific question. I would have advised him. That's my general practice, not the Bruton. We're not talking about co-defendants here. We're talking about witnesses who have a Fifth Amendment privilege. So
your time is
up.
Is getting there. Just a quick question on the colloquy.
Sure.
And whether it was intelligent. It seems to me it's not enough to show whether the judge didn't inform the juvenile of the maximum punishment or the ACCA potential. One has to show that that would have made or likely made a difference to the juvenile, and that's not in the affidavit. The juvenile just says this would have been important information to have.
And let me just respond quickly. I will say, and I was looking, I realized, I think often where they say it would have made a difference is where, at bottom, the court is convinced that the defendant or the child, apart from any technical violations, it was a knowing voluntary waiver. As the court is aware, the child, slow processing, not very bright, and it is actually, the colloquy is 93 pages in the transcript. We have already gone through the child gets asked, the judge tells him that he will change the deal at page 83. We have gone through the plea colloquy, we've gone through the statement of facts, we've gone through the victim witness impact statement, we've gone through the mother speaking, and at page 83, the judge says to this kid who's got an IQ of 81 and slow processing speed, who can't take information, oh, I'm changing the deal. You're on probation as of today. And by page 85, while court's still going on, everybody's talking, the court's talking.
You're talking about what the juvenile knew and understood at the time. What I'm asking about is what the juvenile put in his affidavit. Now that he's been fully advised by appellate counsel, he still can't bring himself to say, I would have done something different. I would have gone to trial. I would have rejected the plea. He just says, that would have been important information.
I think it's the combination of all the factors, and I think that's what the court has to look at. I think it was an unknowing plea because he was given poor advice and because he may have understood one deal, but it wasn't until about the very, very end of the colloquy that the judge says, sorry, jig's up, you're getting a different deal, pal. Your probation starts today. And I think that in the case, the way I read the cases where they reject whether, well, this one, actually, probation isn't a technical violation, but where they assess whether it was still knowing and voluntary, there is evidence of it being knowing and voluntary. And I don't think it's possible that between page 83 and 85, this child, perhaps any adolescent, could have understood what he was then agreeing to. And again, I would just refer the court to the articles on the adolescent brain development. Thank you.
Thank you. Ms. Borges?
Good morning. May it please the court. Danielle Borges on behalf of the Commonwealth. Regarding the juvenile's ineffective assistance argument, he has failed to meet the burden with both prongs to the Safarian test. Initially, his claim of ineffective assistance contradicts his previous sworn statements during the plea colloquy, where he expressed that he was satisfied with his counsel's representation of him. Regarding the claim we discussed that trial counsel did not inform him of privileges the Commonwealth's witnesses may have invoked, the motion judge properly credited trial counsel's statements that it was his general practice to inform his clients of the evidence that may or may not be introduced should the case proceed to trial. And furthermore, as discussed, the claim that both witnesses would have asserted their Fifth Amendment privilege is based on several layers of speculation, and the Commonwealth does think it's worth noting that while the full file was not provided to appellate counsel, that was partially because of the delay in time between the plea and the motion for new trial. The juvenile was apprised of the fact that his file would be destroyed following 6 years, and he still waited 9 years to bring the motion for new trial.
So can we focus on this question of how speculative it was that the witnesses would have invoked their Fifth Amendment privilege? So is it possible that the juvenile says, I'm not, had I been, if the juvenile were advised of the possibility that they would invoke, then can the juvenile show up on trial date and counsel requests a Martin hearing, the judge finds that both witnesses have a legitimate fifth and they're going to invoke it, then can the juvenile say, okay, in that case, I'm taking the plea that I was offered before, and that the Commonwealth would say, okay, you got it?
I think it's highly unlikely, given the history of this case, that had the juvenile declined the initial plea, I can't be 100% sure of what trial counsel would have done, but I think it's reasonable to infer that that plea would not have been available just due to the nature.
Let me take it in two steps. One, is it legally permissible? I mean, it's permissible to plead out at any, or at least to offer to plead at any time, and to see if the old deal is still available. So there would be nothing barring the Commonwealth at that point.
Correct, but I think that goes to trial counsel's representation of the juvenile, I think then you would have had a stronger claim. The juvenile ultimately received a very favorable deal in this situation, and I think it would have been a stronger argument of ineffective assistance had his trial counsel told him, oh, deny this now, see what happens, and it's a risk essentially whether the Commonwealth, he still could have pled, maybe the deal wouldn't have been as favorable as it was. So I think he definitely could have still, rejected the plea and seen what the witnesses would have done, but that probably, I think, would have been a further argument for an ineffective assistance claim.
There's nothing in the record that states that the Commonwealth's plea offer was contingent on the juvenile accepting it at this time, and as it gets closer, it would be
Correct.
taken off the table. There's nothing in the record to that.
No, that reflects that.
Can I ask you about the colloquy issue? Is there any case law that says what type of consequences like ACCA have to be provided to the juvenile or the defendant in order to make the plea knowingly, voluntarily, and intelligently made?
Yes, I believe the Commonwealth cited a few cases in its brief where there are certain rights that, yes, they do need to be. I know with the Padilla case, that's a big one with immigration consequences. There's a few other ones that I don't have off the top of my head, but I know they are in the brief.
Talking about enhanced, this is basically ACCA. I know the SJC doesn't like to use it, but it's an enhanced penalty.
Correct.
What type of enhanced penalties have to be provided to the defendant or juvenile at the time of a plea? What's the case law say about that?
Off the top of my head, I can't. My understanding is that enhanced penalties, such as ACCA, they're considered collateral. They do not need to be advised of that because they are possible consequences, but not foreseeable. They're not 100% guaranteed. So any consequences that kind of follow that line of reasoning, the defendant does not need to be apprised of that prior to offering a plea, and the fact that they weren't apprised of that and later suffer those consequences does not retroactively make that plea unknowing or involuntary. And just regarding the plea colloquy, the motion judge, the plea hearing judge is able to rely on a defendant's sworn responses to the judge's informed questions, and their responses do matter greatly. In this case, off my counting, the juvenile was asked 14 times during the colloquy whether he understood what the judge was telling him, and he answered in the affirmative each time. This was both before and after.
That he understood what the judge was saying doesn't mean that he also knew what the judge wasn't saying and was taking it into account. So that doesn't seem to get you that far.
Well, if we're talking then about the Rule 12 where he wasn't apprised, is that the kind of, so in that case, non-compliance with Rule 12 doesn't automatically invalidate a guilty plea, and each case must be analyzed individually to determine whether compliance with Rule 12 at the time of the hearing would have made a difference in the defendant's decision to plead guilty. And the burden's on the defendant to provide plausible evidence that if he had been fully informed, he would have preferred to go to trial and face the minimum and mandatory sentences. So as discussed, the juvenile was facing a minimum mandatory sentence of 20 years on the armed home invasion, and that was only one of 3 charges that were brought. So the motion judge properly found that it was unlikely that even if the juvenile had been given this full information in open court, he would have declined to plead guilty and go forward to trial facing that minimum mandatory.
So just to be clear, you agree that being informed about the maximum sentence on the ABDW was required, but was omitted, and you're saying it's not prejudicial.
Exactly.
And your position about the ACCA consequence is that it was not required.
Correct. It's not required as it is a collateral consequence. So I know the juvenile makes the argument that both his counsel and the judge should have apprised him of that information. It is not required. It is a collateral consequence. And as discussed, his affidavit, where it only stated this information would have been helpful or important for me to know, that does not meet the materiality requirement that is necessary to demonstrate that his plea was not voluntary or intelligent.
So I think in the, it's either the immigration consequences context or the Dukan context, the affidavit has to assert at a minimum that the defendant would have gone to trial, and then the defendant has to satisfy the, in the motion to withdraw the guilty plea, has to satisfy the judge that that would have been a rational decision. Do those requirements apply in this context as well?
My understanding is that, yes, for any sort of this withdrawing of a guilty plea, they do have to prove that they would have elected to go to trial, and that would have been a rational decision. And in this case, the Commonwealth's position is that the juvenile has offered no evidence, and it would not have been rational for him to choose to go to trial.
So what case says that in a context like this one, or a context outside of immigration consequences or egregious misconduct, that the affidavit has to assert that the defendant or juvenile would have gone to trial, and that that has to be shown to be a rational decision? What authority do we have?
I don't have it off the top of my head. I can certainly check my brief and supply the court with a supplemental letter.
I didn't see it in your brief. If it's there, if you could let us know. If you have a
absolutely.
case that wasn't there,
Yeah, no,
let us know.
absolutely. I can do that. If the court has no further questions, the Commonwealth would ask that they affirm the motion judge's ruling and would rest on its brief.
I have a question about Rule 12. I guess it was 12C3B at the time, and now it's 12C3A2A, if that's right.
I do believe that was a change.
So there is now a requirement in 12C3A2D that the defendant in a colloquy be informed if an offense to which the defendant's pleading can be a predicate offense for the habitual offender statute. What does that say about whether the defendant needs to be informed that the offense to which that defendant is pleading can be a predicate offense for ACCA?
I think moving forward, it's not harmful to advise a defendant in that case. I don't think that was.
Sorry, it's not harmful to it?
I don't think there's anything wrong with making that applicable to defendants moving forward. I don't think that was the standard at the time of this plea. And even if it was, I still would go back to the Rule 12 noncompliance not being an automatic disqualifier to whether a plea was knowing or voluntary.
Well, I guess my question is, does the fact that the rule was amended to require that those pleading guilty be informed that the offenses to which they're pleading guilty may be predicates for a later habitual offender charge or enhancement, does that tell us anything about what the phrase earlier in the rule means about they have to be informed of any different or additional punishment based upon subsequent offense provisions of the general laws? If the habitual offender statute were a subsequent offense provision of the general laws, then wouldn't the defendant already have had to be informed that predicate offenses, that the offenses to which the defendant was pleading guilty could be predicate offenses for the habitual offender statute, even before that amendment was made to the rule?
I might be not following, but it's my understanding that since that wasn't the rule at the time, he was not entitled to it at the time, it kind of, like I said, I think he could have been told that, but he wasn't required to be told that at the time. And just like, and ultimately, the Commonwealth's position still would be that the plea was still knowing, and it was still the rational decision for the juvenile to accept the plea.
But you don't know of any case shedding light on what the phrase in the Rule 12 means, subsequent offense provisions of the general laws?
Not off the top of my head, but again, I could research that and provide that in a further letter.
Further questions?
No? Thank you.
All right, thank you. All right, our next case will be number 22P524, Commonwealth versus Mayanja. Mr. O'Brien.
Good morning, Your Honors. Edward O'Brien for DAUDAH, Mayanja. One of the safeguards against wrongful convictions in rape cases is the requirement that the Commonwealth has to prove force, at least constructive force, beyond the reasonable doubt. And it's The definition of constructive force from Caracciolo case is there must be proof beyond a reasonable doubt of threats or conduct calculated to instill fear in the complainant. And this requirement of force negates possible mistake as to the consent. Now, the record in this case is completely lacking of this requisite force. And I believe the Commonwealth would even agree there is absolutely no evidence of actual force. Case proceeded to the jury on the ground of constructive force. And there are no threats anywhere in the record from Mr. Mayanja. There
have to be threats for there to be constructive force.
Well, I would say, Your Honor, not threats nor any part of his conduct was calculated to instill fear.
So the definition of constructive force would be conduct intended to instill fear?
I'm taking that definition, Your Honor, from the Caracciolo case, which is threats or conduct calculated to instill fear in the complainant in order for the defendant to achieve his goal. And the evidence in this case, there is none that there was any conduct on Mr. Mayanja's part to overcome her resistance or anything. There's no physical force. There's no threatening words or gestures.
So
it's the exact...
Caracciolo, you're quoting language about is calculated to instill fear. The model instruction, as I believe you quoted in your brief, just says that the threatening words or gestures that operate on the mind to instill fear. So it seems like the model instruction is a little bit less stringent than the language you're quoting from Caracciolo.
The model instruction, yes, Your Honor, does not use calculated. And the word calculated is at page 653 of the Caracciolo case. So that implies certainly an intent element. But objectively speaking, without even getting into the defendant's mind, or without even getting into his subjective intent, is what conduct of his establishes and instills fear in this complainant. It's the exact opposite as far as threats. He flatters her.
She did testify she was in fear, right?
She testified. She did not use the word fear. She was asked on direct, Your Honor, what my client was saying to her, and she says, I can't recall, I was scared. She also testified that she was frozen.
Right.
She said, well, what, did you do anything to keep his hands away? No. She never said no. She never said stop. She never pushed.
But her testimony that she was scared and frozen, that's enough to show she was in fear, right?
I would say yes, I certainly.
But that's not enough to prove
fear.
Constructive force, because why?
I think the focus is not on her subjective state of mind of fear. I don't think there's consent in her mind here. It is, what did the defendant do to instill that fear? It cannot, a complainant, I would submit, cannot have an irrational fear or a fear that is not based upon the defendant's conduct. The defense conduct, my client's conduct is key. She voluntarily gets in. He doesn't confine or restrain.
There has to be force beyond that necessary to accomplish the penetration.
Which is correct. Lopez, Your Honor. The only case
okay.
is...
So what exactly counts? I mean, what about unbuckling the belt? Is that more force than is necessary to accomplish the penetration?
I would say no. It is necessary to accomplish the act. We're talking about force to instill fear. Unbuckling the seatbelt is not one of them. If
unbuckling the belt on her pants.
None of that. All of that is the force necessary to accomplish the act, Your Honor. It stems from, there you know, she voluntarily gets into the Uber. There's no restraining locks. He's not, he doesn't possess a firearm. He has no weapon at all. He doesn't even threaten a weapon. She voluntarily gets in the cab. She voluntarily gets into the front seat. The route taken is the route to her home. He is not taking a mysterious turn to a deserted, secluded area
What
at
about
all.
the fact that they're in a moving car at first?
Okay. So
What could, I mean, I guess the perspective from the Commonwealth would be, what could she really have done except say no, which would have put her potentially in harm's way when she's in a moving car with the defendant who all of a sudden, again, from the Commonwealth's perspective, this driver starts to put his hands down her pants?
I would first say in response to that, Your Honor, there is no evidence that she would be put in harm's way if she said no. There's no evidence of that. The fact that she is in a moving car, she is where she's supposed to be. She was not forced into it.
She was in the back seat. And
She got into the back seat.
voluntarily asks to go to the front seat, right?
And went into the front seat on her own, yes.
She put herself there.
She did.
Not where she was supposed to be. She put herself there.
Correct, voluntarily.
So,
Correct.
again, she's in a moving car, and isn't that constructive, potentially, from the Commonwealth's perspective?
I would say absolutely not. She is in the car where she intends to be. She intended to get a ride home in a moving vehicle. He did not confine her anyway. And I would submit, Your Honor, she is not without control. She does have control. She has her cell phone. The cell phone is always with her in that Uber ride. She is texting her friends. She is texting her boyfriend. At any time, obviously, she can call
Could I try a different fact pattern? So let's say a woman is, or somebody is in public place, a park bench, and someone comes and sits next to them and puts his hand on her shoulder.
Right.
And she freezes, which I think is not an unnatural reaction. And she doesn't say anything, and then he penetrates her with his finger, let's say. Are you saying that there are no circumstances where sexual contact is so unexpected that a victim can be deemed to have the inability to consent in a way?
I don't know if I would go that far, but we can see the implications here of this case.
On the park bench example, in your view, would that be enough for constructive force?
Unless there's force. Force is the...
So someone's just sitting on a park bench, minding their own business, and
Yes.
the defendant comes and sits next to them and makes unwanted sexual contact very suddenly. That's not enough for constructive force.
What we have in your example, I believe, is we have here is a totally passive complainant. She makes...
Same in my hypothetical.
Yep, it's
Passive.
it's the same. And I would submit, in that case, Your Honor, there still has to be a proof of force. In fact, the case law, there is no case law that in which somebody has been convicted just by touching somebody, even a stranger. It's always, when you're dealing with a completely passive victim, they've either been incapacitated by way of alcohol or mental defect, or a completely passive victim, the convictions have been affirmed, where that person has been the victim of long-standing abuse by an authority figure.
And the problem I have with that, if you consider all the different potential fact scenarios, is that the passivity can often arise from fear or surprise, from unexpected sexual contact. So it seems like you're saying that in no situation could that ever constitute
I would
constructive
say, in order to
force.
guard against wrongful convictions, that that is my position, because even though, I mean, it has not happened to me. I have not had sex in an Uber or a taxi or a bus, but it does happen. Therefore, the law imposes the force requirement in order to convict a defendant of rape. And the only cases historically in Massachusetts that have imposed and affirmed convictions for completely passive victims, again, is child abuse. Or the Newcomb case, you had an adult female testify that her biological father had sexually abused physically and mentally since the time she was about 13 years old, 11 or 13. But even with the authority figure, and the Commonwealth is really placing, I think, attempting to place and equate an Uber driver with authority figure. And I would say, first of all, he is not an authority figure as what is shown in the cases.
I don't think that's it's that it's just a situation where the contact is so unexpected. Or let's say mere seconds elapse between his putting his hand on her shoulder and penetrating her. Would that make a difference in your view? It's mere seconds.
There has to be, again, I know what Your Honor is asking me, but I still think there has to be that some element of force, conduct on a defendant's part designed to put the complainant in fear. So here, I mean, we have a case where he flatters her, he starts, he doesn't get physical, he puts his hand on her hair, her shoulder, and progressively moves down, and she says nothing. She makes no attempt to resist. It would be the same situation if she met a stranger in a bar for a few minutes, they talked, he says, "Can I give you a ride home?" It's the safeguard, again, I keep coming back to this, the element of proof establishing force beyond a reasonable doubt is the safeguard for wrongful rape convictions here. Because as seen in the first case, the issue of a good faith, there's really no good faith exception or subjective belief by a defendant that he has consent. And again, the law where a complainant is completely passive, never has that been extended to a situation like here. The Commonwealth relies on evidence that Mr. Mayanja was an Uber driver, that it's against Uber policy to touch people. Okay. First of all, Mr. Mayanja doesn't equate to, say, like the person in Caracciolo who was pretending to be a police officer. There's an authority figure. But even if somebody is an authority figure like a parent, all the cases always combine the authority figure with force. Against Uber policy, well, it may be an employer has a policy against sexual relations between employees, but it happens. And the fact that it happens and it's against the employer policy doesn't automatically mean that it's a rape. The same with the prescriptions for lawyers having sex with clients. It happens. And if it happens, the ethical rule against it doesn't make it rape. The same here with the Uber policy.
Can I go back to the point before the policy and ask, are you saying that the fear has to arise from something other than whatever force is necessary to accomplish the penetration?
Correct. Some conduct of the defendant.
Okay. So what about putting his hand on her shoulder and then her arm and then her thigh and so forth? Is that more force than was necessary to accomplish the penetration?
Well, for me, Your Honor, force is tied up with conduct of threats or conduct that is just beyond touching. There's a threat. There's a case about a defendant that said, hey, if you don't do as I say, then the spirits of your ancestors will come back and harm you. It's always, the conduct is always combined, the touching is always combined with the threat. And it's the fact that sexual advances, according to the Commonwealth, are never appropriate in this situation. We have seen situations where passengers have sex with Uber drivers. I mean, it just happens.
What
We're
if
gonna
the-
have to-
Oh,
sorry.
sorry, one more quick. What if the victim didn't have time to object? How would that play out?
I'm sorry, Your Honor?
What if the victim doesn't have time to object?
Doesn't have time?
Because the events unfold so quickly.
Well, respectfully, that's not.
I understand. I'm
that's not
trying to
this case.
probe the rule that you're asking us to adopt. So let's say the victim is passive because she just doesn't, the events unfold very quickly and she doesn't have time to object. She freezes. In your view, that's not enough for constructive force?
I apologize, it's a little vague. I believe Your Honor is referring to a situation where a complete stranger comes up and touches and starts.
Or in this facts of this case, let's say it was just very sudden, the act of penetration was very sudden. It wasn't he didn't lead up to it by putting his hand on her shoulder. It just happened very suddenly. In your view, that's not enough for constructive force?
It would all depend on the circumstances of the action, whether there was threats and gestures designed to instill fear.
There's no threats, no gestures. It's just that it happened very quickly. She's in an Uber. She's expecting this person to drive her home.
Right.
And on the way home, he suddenly decides that he's going to
A sudden
assault
attack,
her.
I would say that has a more likely view of a threatening encounter, but that's not this case.
All right.
All right, thank you.
Thank you.
Mr. Lynn.
Good morning. Let's try to get the first word right. Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. With me at council table are the trial prosecutors, Lynn Fagenbaum and Carolyn Merck. What Newcomb and Caracciola say is that constructive force may be threats or threatening gestures, and that is consistent with the model instruction that the defendant requested in this case. It is not required, and Newcomb is a perfect example of that, in which there were no immediate threats. There was simply this pattern of conduct leading up to the incident based on which the defendant was convicted. And that's exactly what we have here. We have a situation, as the prosecutor argued, in which the defendant is literally in the driver's seat. He is a stranger whom the victim has hired to take her from one place to another. And she has a right to travel from one place to another without being molested. That's not just a norm. That's not just a situation in which you could get fired for committing this act. This is a situation in which a person would not expect to be molested. And I think that's my brother points out that there are these articles about people who like to have sex with their Uber drivers. But that's an entirely different situation. That's a situation when you have affirmative consent. And there are many things
that's one of the problems I'm having with this case, is that it seems like you're saying that in this type of situation, all the Commonwealth has to prove is lack of consent.
No, we are arguing that in this situation, where a person, where a stranger who has been hired to carry a person from point A to point B in a moving car, which the victim has no safe way to escape. This is someone she doesn't know. She has no idea what he's capable of, what he will do if she says no. That's why we don't require victims to say no in the law. So it's not just non-consent. It's
right, but this particular fact situation of a rideshare driver, taxi driver, what have you, someone picks up a hitchhiker, that in all of those cases, unless there's evidence of consent, then the elements of rape would be proven, right?
That's correct. That's the
So it seems like it's just the defendant's status as a rideshare driver and being in a moving car, that enough, in your view, is constructive, to be constructive force?
Yes, I think the combination of those factors, and that's consistent with the language that says you can consider attempts to confine. You can consider the relationships between the parties when determining whether or not force has been proved. And he does ultimately go off route. He ultimately does turn off into the area around the hatch shell on Star Drive and continues to rape her. So he does.
He says he's going to do that before he does it, correct?
No, he pulls over and then he says, nobody has to know. He doesn't say, I'm going to pull over now.
He doesn't say that?
No, I'm almost certain he doesn't say that. So she does, of course, she has her cell phone with her, and the defendant concentrates on a lot of things the defendant didn't do. But he did do enough. And she does, as soon as she sees a safe opportunity, when she gets a call from Lori's boyfriend, Mr. Barham, she takes that opportunity to say, oh, could you please let me out so I can take this call? And as soon as she's out of that car, she runs away. And the evidence of that, she's terrified. She immediately, on the phone with Mr. Barham, says, I've been raped by my Uber driver. Mr. Taglieri, who's looking for his dog, sees her crouched down in fear and says, don't let him find me, or yes, I'm in trouble, depending on which witness you believe, but certainly an immediate statement that she is in fear, that she is in trouble. And according to Mr. Taglieri, the defendant gets out of his car to come after her. And of course, the jury could believe that that was just concern for her, but it also implies that he is trying to prevent her from reporting the rape. So you put all these things together, the relationship, the confinement, and the sexual assault by a stranger, and you have constructive force. So enough evidence in the light most favorable to the Commonwealth to prove.
Can I just back up a second? On cross, the victim was asked, when he was pulling over on Storrow Drive near the hatch shell, did he tell you he was pulling over? And the victim says, uh-huh. And then the judge says, well, you got to say yes or no. And then defense counsel says, again, so after he told you he was going to pull over on Storrow by the hatch shell, you didn't say don't pull over, correct? And the victim says no.
I apologize, Your Honor, I missed that.
May I ask, just, can you refresh my memory at least? Could the Commonwealth have proven indecent assault and battery here without...
Yes, it's a lesser included offense, so
okay,
yes.
Without having to show force?
Without having to show force.
So the Commonwealth could have charged that, and
Correct.
This force issue wouldn't be in the case?
That is true. But it is also penetration, so it is where there is force, it is rape as opposed to indecent assault and battery, which doesn't require penetration. So that's why it was charged as it was.
So I guess what's troubling me is that there's no affirmative act or word that the defendant, he didn't say anything or do anything, right? So I'm just trying to probe how far this would take us. So let's say you have another situation where sexual contact would be totally inappropriate. Let's take a college professor and student example, and they're in his office and the door is closed, so it's a confined small space. Is that enough for constructive force?
I would say yes, under the circumstances. You in the light most favorable to the Commonwealth, if the same acts occurred in the same sequence in that situation, and of course the victim didn't consent. That's always right. If we have to prove that the defendant, and that's the big difference between these civil suits against employers and rape is that, well, I won't say the civil suits, but the ethical requirements, because the civil suits usually are based on lack of consent too. But the real difference is a professor isn't guilty of rape if he has a consensual affair with one of his students. He may be guilty of misconduct under university policy and he may get fired, but he can't be convicted of rape because there was consent. And,
so how do you define constructive force then? Because the way that the model instruction reads, it's threatening words or gestures and operates on the mind to instill fear in the complainant in order for the defendant to achieve his goal. So in the college professor example, what would be the threatening words or gestures that operates to
Well,
instill
again,
fear?
I point out the fact that the language is constructive force may be threatening
I
words
get
and
that,
gestures
yep.
and operate
So
on
then
the mind.
if that's not the actual definition, what is the definition of constructive force?
Well, I think you go, the next sentence in the model instruction says, there must be proof that the complainant was afraid and that the complainant submitted to the defendant because his conduct intimidated her. So you're still looking at the
So
circumstances.
there has to be
in the-
intimidating conduct.
I'm sorry.
There has to be intimidating conduct
Correct.
by the defendant that
Correct.
compels essentially the
Right.
victim to submit. So in the college professor example, what is the intimidating conduct?
That he is her
That he is a
teacher. He's
professor?
his professor, he's responsible for her grades, he's in a position of authority, he is presumably older, though obviously not necessarily, in this case it would be. So you have all these factors, and again, the same sort of situation which is why these policies exist, because, we believe that women have a right, and men as well, of course, but usually women, have a right to go to college, to hire public transportation, to travel, to check into a hotel, all these things without being sexually molested. And so I think really in the 20 teens when this took place, this is the situation, the law is that a reasonable person could, in this situation, would realize that you can't do this unless you are very, very certain that you have consent, because otherwise you're liable to be prosecuted for rape.
I want to change the facts of this case ever so slightly.
Of course.
The driver, exactly what happens, except the victim gets right into the front seat, asks the Uber driver, I'm going to get car sick if I sit in the back seat. Can I sit in the front seat? Sure. She gets in, they start driving, he starts touching her shoulder, arms, etc., clearly flirting, and then at a red light, he starts to go into her pants. Does that change the situation because the car's not moving and she could just get out of the car?
It lessens the situation. I don't think it changes it. I mean, obviously, she's still in the middle of the road.
Where
there's
is the
traffic.
force in that situation?
Again, I think it's the combination of the fact that it's a stranger, she's confined in the car, she's
not confined
I mean,
in the
she can jump out into traffic, but that makes it just ever so slightly.
Let's say there's no traffic.
Yeah, I mean, I think as you keep ratcheting down the facts, it comes closer and closer to insufficient evidence.
Seems, going back to Judge Shin's initial question, it seems like you want to say it's rape almost solely because he's an Uber driver.
Not because he's an Uber driver, but because it's I mean, I guess it's the fact that he's an Uber driver doesn't, just change it from a
So if
taxi
I'm driving
driver
an acquaintance-
or a professor or anything like that. It's just, he is it's not so much an authority figure, but he is a person who, for the duration of this trip, has significant control over the victim. That's what the situation
If I'm driving an acquaintance home and there's no authority relationship between us, and I do exactly what this Uber driver did, am I guilty of rape?
Again, that ratchets it way down because you don't have the stranger factor.
I'm asking you, is there sufficient evidence?
Yeah, I mean, that would be closer.
Is it sufficient or not?
I would think under the circumstances, it would be very close. I would say probably, probably no. And I would say certainly in those circumstances, that would be more of a situation in which a woman would say, whoa, what's going on, as opposed to, being in fear of a stranger who she doesn't know what he can do.
But is the fear that stops the victim from saying what's going on a response to constructive force?
In your hypothetical or in this case?
Well, either, but let's start
Well,
with
in this case, yes.
Start with my hypothetical.
Yes, but in your hypothetical, she obviously, if she feels intimidated, and it's just a question. It's not. I guess the answer I would say is it's not the mere fact that she's intimidated. As I concede my brother's point that there does have to be some circumstances that amount to constructive force.
What evidence was actually presented by the Commonwealth that she felt intimidated?
Because she said she was scared. She said there was no place to go. We certainly presented the evidence that as soon as she had an opportunity to get out of the car, she did. She said she'd been raped. She hid. She almost fell into the Charles River. When Mr. Taglieri showed up, she said, "I'm in trouble," or "Don't let him find me." Where's the fact? There's ample evidence that she was intimidated.
But that's not enough, and you concede that. It's not enough simply that she felt fear. He had to have done something to put her in fear.
Correct.
Okay, can I turn to the instruction?
Yes.
Where was that ever told to the jury? That he had to have done something to intimidate her, to compel her to submit, essentially, in order for there to be constructive force?
The instruction that was given was that the jury had to find force, either actual constructive force or threats of bodily injury. Examples were given for confining
Well,
the
there's
victim.
no threat, and there's no physical force. You would agree, right?
Yes, there was
Okay,
no threat of violence,
And there's no
direct threat.
definition of what constructive force is. And even as we're sitting here today, it's hard to define
is,
it with
and
any
I would say if
precision.
you
So
look at the
how is the
construct-
jury supposed to know what it means?
Well, there's many times we ask the jury to ask, like, what's a reasonable person?
But we have to define the element for them, right? I mean, like, so where in this instruction were they ever told what constructive force means?
They were given the example that I cite in my brief of confinement, that in the ellipsis in my brief, the judge went on to say there can also be, you can also find it based on evidence of violence or a struggle, but you don't have to find that happened. You just have to find there was constructive force. And if you look at the model instruction, it too just is essentially a list of factors they can consider. I see my time's up.
Well, no, the model instruction says that there must be conduct that operates on the mind to instill fear.
Well, again, it says there may be threatening words and gestures that operates on the mind to instill fear in order for the defendant to achieve this goal, but there must be proof that the complainant was afraid and that the complainant submitted to the defendant because his conduct intimidated her. So you do, that instruction does say there has to be intimidating.
Right, and there's nothing like that in the instruction that was given. And isn't there a risk that the jury might have taken the confine or restrain language and found that because she was in a confined space, he didn't lock the doors or anything, right? So isn't there a risk that they could have found that because she was confined in a car, that was enough?
That would be.
But that alone would not be enough, right? Just that she's in
enough. I mean,
that she's in a car, that's enough?
Yes, that he made this, that he used this force on her while she was trapped in the car. Yes, that would be sufficient. I don't think what the law is extremely unclear on, and I could not find a case one way or the other, is what the defendant's state of mind regarding force has to be. And I don't think the giving of the model instruction would have changed. I think this is not a case in which the instruction wasn't given, as in Desiderio, which just came down last week, so much as the judge didn't use the language the defendant requested, which is a whole other situation, and one in which the courts have consistently said the judge doesn't have to.
All right. Thank you very much for your arguments. We'll take our morning recess now, about 15 minutes.
session. Please be seated.
Good morning again. We are here for our fourth and fifth cases. The fourth case is 22P898, Department of Children and Families versus Mother and Others. I would remind the parties, I'm sure you are very familiar, the case is impounded. No names, please. Roles such as child, older brother, older sister, mother, whatever you need to do. I just want to make clear the appellees are splitting your time equally, and Tyler Carroll is first for the department.
That's correct.
Okay, thank you. All right, Mr. Penta.
Good morning, Your Honors. It's Michael Penta, and I represent the appellant mother, and may it please the court. I do raise a number of issues of error in my brief, but I'd first like to start with the due process claim that presents an unusual but serious procedural due process hazard, which is twofold. First, a judge's delay in issuing her decision and findings should not operate as an invitation for the department to weaponize that delay for the purpose of reopening the case to present evidence of the passage of time. Because when bonding specifically is an issue, naturally it occurs, and this court has warned numerous times that bonding should not be the self-fulfilling prophecy of finding a parent.
But is there any indication that the situation with bonding was significantly different or significantly less bonding at the time in January of, I guess, 2020, when with Mother's Counsel out of the courtroom, the judge said, well, so you're saying you don't want me to issue my findings that I already have?
Well, I think that,
how do we know things became less favorable for the mother such that she was prejudiced by the delay?
well, the delay in and of itself, the passage of time to a parent who's separated from their child can only operate as a negative impact to that family.
Well, of course, no one wants to be left in limbo, but your specific argument is about the, what you, I think, assert is the increase in the strength of the bond, which therefore made a stronger case for DCF on Factor 7.
Of course, because when the child was first removed from mother's care, and I think the findings from the judge is that, first of all, the visits during the interim had generally gone well, according to the judge's findings. But at the time of the removal, the child was, by the department's even own reports, bonded, wanted to return home. Then the case is taken under advisement. I describe it as putting the parties in limbo. What it really is a due process term with lack of notice to a parent that in the duration of this passage of time, that there's going to be this rolling trial, that they're essentially going to be held accountable for their actions post-trial simply by the passage of time. So, for example, the one fact to answer your
I guess I'm getting confused because now you're talking about the mother's actions after trial.
Well,
whereas I thought we were talking about the strength of the bond.
Correct, and I got a little off track, but I did want to stress that there's a multiple issues that happen with the delay in the issuance of the findings. The first and foremost would be the ongoing bonding. There was a finding by the judge that she latched onto about the child having issues with returning to the mother because she had asked him about what color she wanted her to paint his room. And that is in stark contrast to what was happening before trial. So these delays have a negative implication on these families, the children as well. And so there was a negative impact on the bonding, as the record would suggest, but it's due solely, again, to the passage of time, because it's not consistent with what the relationship was at the time of trial. It took what I like to call a borderline or close case and pushed it more into a category of unfitness, simply because there had been a significant and unnecessarily delay in issuing the findings. And much of the judge's findings after what we call the second trial were based largely in part on the facts of what happened in the interim while the parents were waiting for a decision. And I must remind the court, too, that the judge throughout this knew. I mean, those were repeated reassurances. My decision's forthwith. I have to issue it within 30 days, but I'll do 45 days because child would like to submit findings of fact in 45 days. 15 days is not going to be an issue. Then in November, the mother reminds the court that there's no decision, and the judge says, oh, my decision's imminent. And it'll be forthwith, and we're going to schedule it out for 6 months, which is really a code word in the care and protection arena for we're going to schedule something, like I haven't made a decision, but it's not termination. 6 months is a code word for review and redetermination. Then in a hearing, when they decide to reopen the evidence and mother's not in the courtroom, the judge says, I have my findings, but I'm not going to issue them because the department asked me not to. And that's a significant factor as well. Because
before you get to that, counsel, and I know Mom's trial counsel did ask about the findings, but was there any tantamount to an objection at any point about the timing to say, Judge, we object to you taking this long to make your findings? Was there anything like that? And I know it's a difficult strategic decision there, but
I think there's a general and then there's a specific answer to that question. There's a general answer. There's a direct answer is no, there wasn't an objection on the record. But this court is not bound by whether or not there was an objection on the record, especially in due process claims, if justice is going to be, what's the operative word, is going to be defeated rather than promoted. But secondly, how can you object to something if you're not in the room? It's if a tree falls in the woods and you're not there to hear it.
I'm talking about even before that. You meant, the trial happened, then there was 30 to 45 days, and then it kept going. At some point, counsel for Mom could have filed something, whether it be a written objection or something that said, look, we want the findings. We object to any further extension of time.
Well, with respect to the findings, mother was not aware, or her counsel was not aware that the judge had in fact made a decision, which is, we can't make an assumption that mother was unfit. There was we make an assumption of guilt. We don't make an assumption of innocence. We don't make an assumption of unfitness. The judge did not make a decision. So it's reasonable for mother to conclude, for all the parties for that matter, to conclude that the decision is going to be coming imminently. The judge herself said it a couple of times. So to raise that the mother's counsel didn't file a motion, well, it was known to the judge. The purpose of an objection is to put the court on notice. The judge was well aware of the time standards to issue a decision.
The delay was known to the judge.
Correct.
That's for sure. But it sounds to me like you're arguing prejudice not from the delay, but from the reopening of the evidence. And that
Correct.
There was no objection. And that the judge should have been put on notice if there was an objection to reopening the evidence.
Well, there's an affidavit subsequently submitted by mother that she was unaware that the judge had issued her findings. And there's a statutory mechanism for dealing with these situations called a review and redetermination, where the judge makes...
The affidavit, which was prepared for this appeal, right?
Correct.
Okay. She says she wasn't aware. She was out of the courtroom when the judge said, I have a decision maybe ready to go at some point soon. But she knew there was a motion to reopen. And she never objects to reopening. So let's say the reopening had never happened, and the decision issued then, or shortly thereafter. And you would be here on appeal then, arguing delay based on stale evidence, right?
No.
Yes. If you're arguing prejudice from the delay, the prejudice is stale evidence, and the remedy would be the reopening of the evidence, right?
Not correct, Your Honor. Stale evidence is a concept that deals with evidence that happened. Like, for example, part of my argument is, in fact, stale evidence because a lot of the development for the child's removal and finding mother unfit, dealt with the oldest daughter. And that situation no longer existed. The daughter was an adult living outside the home, raising her own child. That's stale evidence, something that happened 4 years ago, not something that happened in the interim while the judge is waiting that decision.
Let's say that the judge never reopened the evidence and the decision issues sometime around early 2020. Would you be arguing prejudice from the delay in issuing the decision?
It's not the delay of issuing the decision.
Okay, that's what I'm saying. So the prejudice comes from the reopening of the evidence, right?
It comes from the reopening of evidence to present evidence that happened during the delay, if that makes sense.
So going back to the waiver issue, when the mother's counsel is aware that there's a motion to reopen and there's no opposition filed or no objection made, how is the judge on notice that the mother doesn't want her to reopen the evidence?
Well, if you even look at the department's own affidavit, the evidence is simply the passage of time. The department it's not something happened in the interim, like, for example, and to be fair, it seems like the department would be the only one to present new evidence. If a parent went in and wanted to say, we want to present new evidence, the court would say, we've closed this case, we'll make a decision, file a post-trial motion to vacate or whatever. But here, what happens is simply the passage of time, and the judge's decision is based largely in part on the passage of time. It would be the continued bonding with the child in the pre-adoptive home, and it is the mother's lack of engagement in services, but it's post-trial. There's a parent awaiting a decision, either she's fit or she's unfit.
I guess I'm going to pick up on Judge Shin's question.
Yes.
The evidence had been closed.
Right.
Mom could have objected to the reopening of evidence. She didn't. So we are looking at this as, was it an abuse of discretion for the judge to reopen the evidence? So
Yes.
Tell us what the abuse of discretion was, not what she ended up hearing, but what was the abuse of discretion for her reopening the evidence at that time?
The abuse of discretion lies in the fact that the judge had, in fact, made a decision. And to reopen the evidence once she's made that decision, there's a lack of notice. And the fact is that if the judge has made a decision, and it's only known to the judge and the department, not to the mother, be mindful, the mother was not aware that the judge had made a decision. That sets in track a review and redetermination where parents have notice of what the decision is, if in fact the rights have or have not been terminated, and then what can they do in the interim to either reestablish or, to address those issues. So if the judge was prepared to terminate the mother's parental rights at that time, what was the need to reopen the evidence? And if the judge was finding that mother was unfit, what was the need to reopen the evidence? The department's basis, and these are the facts too, and not to get to the legal part, but the facts, it was just a passage of time. It wasn't, oh, she relapsed, or this happened, or that happened while we're waiting for this decision. So her 3 months or 6 years of sobriety are now combated with 3 months of, it was just the passage of time. The judge's own initiated, self-inflicted delay that was the basis for reopening this evidence, and then using that passage of time to develop a case against the mother. And that just is fundamentally unfair.
Well, even if the judge had not yet made a decision, the mother had to know that reopening the evidence was going to delay any decision even further. You have to schedule the hearing for the reopened evidence, and then the judge has to write findings after that.
It wasn't a perfectly preserved error. I agree with the court here, but I think there are a number of factors underlying that are significant to why that was the case. And that is the largest part, I think, and I said as a practitioner, that a judge saying they have a decision, but they're going to hold it in abeyance to reopen the case at one party's request. I know there was no objection to that, but you don't have all the facts. And if you don't have all that information, it's hard to lay the foundation for an objection. And I would hope to you to this court not to rely on the technical aspect of this, because this is, again, it presents a real due process argument, not just in this case, but other cases where the department can then reopen. These delays are not that uncommon. I think, Judge Shin, as you pointed to, is the issue of, the term's escaping me, stale evidence. That's not for the passage of time between a judge issuing her decision. It's the stale evidence is old evidence.
Well, it can be both,
if there's
right?
new evidence that develops,
if the delay is long in issuing the decision, there is a risk that the evidence is stale.
there's a real risk that the evidence becomes stale, and there is a process. And again, there are statutory and there are methods of addressing that, either through a review and redetermination, filing for a review and redetermination to present new evidence of what happened, which wasn't the case here, because a review and redetermination follows an adjudication, follows a decision from the court, and follows notice to the party what the issues are going to be going forward. It's building off of the old trial. That all happened without that actually happening. So there was essentially a de facto review and redetermination.
Counsel, can I ask you about that, please?
Yeah.
What factors is a judge supposed to consider when he or she decides to reopen a case? What are the factors? Again, going back to the abuse of discretion standard, what factors is a judge supposed to consider about whether he or she should open the evidence?
I would submit to this court that the legislature had committed a reopening mechanism called the review and redetermination. Simply because a judge hasn't gotten around to issuing their decision shouldn't be a basis for reopening the evidence, because, again, it's not noticed. The parties are at a disadvantage because they lack notice that there's no decision.
Does review and redetermination encompass the issue of unfitness?
Well, a review and redetermination, I know I'm running low on time, but
if the judge has already said mother's unfit, does the mother then get 6 months to try to correct?
Well, so
If the judge has terminated?
So care and protection, the nuance of care and protection is oftentimes we're here before the court on a termination. But there are a number of millions of dispositional options at a judge's disposal, including, aside from a dismissal if the department fails to meet its burden, but also returning the child home with subject to conditions, or to a third party, or finding an unfitness but delaying a termination because the parent is making progress, or there may be a fundamental disagreement with what the issues between the department and the parent. So we'll test it. Then the parent's on notice, and then their ongoing actions at that time have consequences because they know what those consequences will be if they don't act. But if a parent's just sitting there twiddling, waiting for the judge to issue a decision, and those fundamental disagreements still exist, and the judge says, well, we'll reopen the evidence simply because of the passage of time, not new evidence, just has been a passage of time, and then weaponize that against the parent because they didn't do what the department wanted them to do in the beginning, it just seems fundamentally unfair to not only this parent, but parents going forward, that these delays are acceptable. Because they are not, because they do have ongoing consequences to the outcome of the case.
Your time is up.
I
want to ask one more
Sure.
question about the prejudice. So let's assume that the delay did deepen the bond and that harm from severing that bond was a decisive factor. We're assuming this. So that's prejudice to the mom. But does that lead to an automatic reversal despite the significant harm to the child?
To answer that question,
It doesn't seem like a good answer here.
Well, the answer is there was no, I would submit to the court, the judge didn't make the necessary findings.
Okay, let's assume the judge had made the necessary findings.
Well,
Then do you inflict the harm on the child to punish the judge for not getting her findings out in time?
So, Your Honor, it's a difficult answer to that question because you don't want to inflict harm on the child. But you also want a process that's fair to the family because these are family rights. That's not child rights. I mean, a parent's right to their child is significant. It's probably, weighs, and as this court has said, it weighs even more on them than the loss of the deprivation of the rights by going to prison. So time and time again, if this continues to endure, we're going to be answering the same question. Do we punish? You don't want to punish the child, but you want to give the family every opportunity to preserve the family integrity, have a trial process that's fair, where they know what the options are.
You're saying it's an automatic reversal.
I'm saying this is structural. I'm saying that this presents such an egregious error, it's structural, yes. And if the evidence is such that at a retrial, that's a significant, the system will work itself out, but it has to be a fair and fundamentally sound system where the parents have rights are also respected in this process, and that the delays are not tolerated to this degree anymore. Because we talk about stale evidence, and we talk about all that. If we have fundamentally right decisions, we wouldn't be having to do. I see I'm out of time, but thank you. Sorry for that last rambling part.
Thank you. Ms. Carroll.
Good morning, Your Honors, and may it please the Court. My name is Tyler Carroll on behalf of the Department of Children and Families. The main question before us today is whether the juvenile court erred in finding mother unfit to parent the child in this case, and that the child's best interests were to terminate the mother's parental rights, and as the record clearly shows, it did not. This is not a borderline case. As the record clearly shows, there is a long history of violence and abuse in the home that started with mother's physical violence against her daughter and progressed to include mother's physical violence of her eldest son.
Counsel, if this is not an open and shut case, why did DCF move to reopen the evidence?
So I believe that the department wanted to reopen the evidence due to, in part, the passage of time and to ensure that the court was working with current standards of whether or not the mother was unfit, and that was the right decision at that time to allow for current fitness to be presented to the court. But as I am currently mentioning, the record already showed by the close of the 2019 trial that there was ample evidence that mother was unfit to parent the child in this case. There was a long history of both physical violence and abuse. Additionally, the child in this instance was the victim of emotional abuse by mother as well. And while the child here may not have directly been the victim of physical violence by mother, it is clear that they were impacted by this chaotic environment. And the court does not need to wait for a child to be the victim of physical violence that other children in the home are experiencing in order to act. It is a strong finding in favor of a finding of unfitness of a parent if there is violence in the home. And under those circumstances, it was not clear error for the court to consider that in favor of a finding of unfitness. But beyond the physical abuse and the violence in the home, the record also shows that there was considerable evidence that mother's mental health issues were impacting her ability to effectively parent her children. A parent's mental disorder is relevant in determining parental fitness to the extent that it impacts their ability to assume parental responsibility. And here the record shows that there was evidence that mother's untreated mental health issues were doing just that, were impacting her ability to effectively parent her children. As previously mentioned, mother's mental health issues were causing her to behave in a violent and aggressive manner towards her children in the home. Beyond that, even after removal, mother's behavior was so inappropriate that her eldest son's residential program banned her from visiting him at the program's residence due to a finding that her behavior was an instigator in his poor behavior and that there was aggressive communications with the staff. The court itself observed after mother's testimony at the trial that her testimony and demeanor on the stand showed that she testified in a pressured and erratic manner, had grandiose assertions, and that it was plainly evident that she had an impaired mental condition.
So since you're splitting your time, I want to ask DCF's position about bonding.
Yes.
You've said that there is strong evidence that there was a strong bond at the time of trial, or at least by January of 20 when the conversation occurred with the mother's counsel out of the courtroom. I looked at the sites. I don't see any evidence or finding about when a bond developed.
Yes, so I think that the testimony at trial by, I believe her name, if I'm allowed to say the social worker's name,
Yes,
Jacqueline Paul, testified that she visited the home of the child and that the child was with his current paternal grandparents, and testified to the bonding that she witnessed. At the time of the...
Well, she witnessed that they were getting along fine, but she didn't talk about bonding. She's not a bonding expert, and I think this implicates the point about where bonding is factor 7 is a decisive factor, not necessarily the decisive factor. There have to be those specific findings under Catherine, which I don't see here.
I think that beyond the testimony of the social worker, there also was testimony, for example, that when the child was first removed, he only wanted to return to mother's custody if there was no more fighting, and that the child did not have difficulty separating from the mother at the end of their visits, and oftentimes wished that it was just him and his siblings at visits, which I think goes more towards the second finding of whether or not there would be a negative impact of a forced return for the child, given the child has a bond. But again, even if at the close of the 2019 trial, there wasn't sufficient evidence to find that bonding weighed in favor of finding of unfitness, I think taking the record as a whole, it was clear that there was clear and convincing evidence that mother generally was unfit to parent the child, and that this one factor was not decisive, as the court indicates.
Catherine says if it's a decisive factor. Are you saying that the bonding and factor 7 and the harm that would inure to the child if he were removed from the paternal grandparents is not a decisive factor?
I think that if memory serves, one of the conclusions of law that the court issued was that no one factor was decisive.
Right. We see that in every single termination decision that comes up. No one factor, but what Catherine says is if it's a decisive factor, it doesn't have to be the decisive factor to trigger that requirement for specific findings.
Right. It's hard to say whether or not that was a specific decisive factor, but I think that given the record here, there was so much other evidence that mother was unfit.
Well, let's assume that it was a decisive factor. What do? Do we remand for additional findings under Catherine? Do we say you can't rely on that, and therefore we have to evaluate the evidence based on the other factors?
I think given the additional testimony that occurred and the evidence that was entered when the evidence was reopened in July of 2020, it showed, for example, that when the child had a conversation with mother about returning to live with her, he had to require therapeutic intervention as he became distraught and expressed a fear of living with mother and not being able to stay with his paternal grandparents.
There's evidence, but there weren't findings.
I suppose that...
Do we assume that the judge would have made the findings if what? If she'd been aware of the requirement? How do we deal with that?
I think that given the evidence in the record, it's clear that there was clear and convincing evidence that the child was bonded to his current caretakers and that there would be a negative impact. And while there may not have been those specific findings, there were other findings of fact that did show that the child was bonded to his current caretakers, that there would be a negative impact of his forced return, and that mother was not able with her current mental health issues to be able to handle the impact that such a negative impact on the child would have if returned to her custody. And I think taken as a whole, those are sufficient findings here, and that does not change the kind of end decision of whether or not mother was fit to parent the child in this instance. I see that I'm out of time.
If you know, when does the department provide funding for a service such as a parenting assessment?
I'm admittedly not sure if there's any sort of general standards on that issue. I do know that the record shows that the department did ask for funding for the parenting assessment on more than one occasion, and that it was denied in part because of the fact that mother had previously failed to participate in services that the department had offered. I do know that they, I believe, provided some other services, so I'm not sure if there's a general rule on that, though.
What factors is a judge supposed to consider about whether allowing a motion to reopen evidence?
I'm admittedly not sure of what specific factors, but I believe that it is adoption of RONA that says that you want to have findings that are based off of current fitness, and I think that that was what was motivating the department to urge a reopening of the evidence at that time, so that while there had already been evidence of mother's previous unfitness from the February 2019 trial, there could then be additional testimony in order to confirm mother's current unfitness at that time. Okay. Seeing no further questions, thank you.
Ms. Comendel?
Comendel, yes, thank you. Good morning, Your Honors. May it please the Court. My name is Tara Comendel. I'm here today on behalf of the child in this matter. And if Your Honor would like an answer to the question asked of DCF, I may have that for you. It's an extraordinary expense, the psychological evaluation that the parents are asked to do. So normally it's through the health insurance of the parent. When that fails, DCF can provide funding.
I thought this was about a parental assessment
Oh,
that
parental.
was recommended. DCF denied the funding, and then the social worker said, well, then go get a parental evaluation, which is the same thing, but you can get it through some other funding mechanism. So
Both extraordinarily expensive, and it's usually when the parent's health insurance fails, the department has to find the money for that because it's a service required of the parent on their action plan. Usually that's the way it works, in my experience. But.
So the parent was, the mother here was assumed to have, or was she known to have health insurance that would cover the parental evaluation? And
that would have been determined by the social worker and the mother at home visits or meetings.
I didn't see evidence about that in the passages that I read about the mother being given names of people who could do parental assessments. Or no, evaluations.
Correct. That isn't clear in the record. It was a referral being made, but that's all that was in the record, Your Honor.
So if a parent doesn't have insurance, can the department deny funding because the parent hasn't been participating in services in the past?
In the evaluation itself. So if she failed to show up for the evaluation or failed to contact the evaluator, those types of failures, not a failure on your action plan of other tasks, just in relation to past requests for evaluations.
Okay.
The child in this matter would ask that you affirm the decree in all respects. Care and protection cases can have a preventive as well as remedial basis. Here, the significant physical abuse suffered by mother's older 2 children was inevitably heading towards this child.
The judge didn't make any finding that physical abuse was likely, did she?
Not likely, Your Honor, but she certainly indicated that there was emotional and verbal abuse of my client.
Okay, so are we supposed to decide for ourselves that physical abuse of this child was likely in the future and therefore?
I think the case law supports that past actions can be.
Can be, yes, but isn't that a question of fact, and are we supposed to be deciding it?
I'm saying the judge determined that in her findings, that that factor was part of, mother's past behavior was predictive of her future behavior in making her conclusions of law.
What are your thoughts about the bonding issue and the absence of findings under Catherine?
Your Honor, I was trying to re-review the findings as I was here. I think that what the judge did was incorporate the fear findings that my client was afraid of his mother and expressed fear to the social worker. So those findings are detailed just prior to the finding regarding bonding. But I would also suggest that these are
Well, there might have, I mean, there may well have been harm, but Catherine requires more than that, that the judge has to make findings about what means to alleviate the harm were considered, why those means are inadequate, I'm meaning those means other than termination, and why the parents' lack of capacity, why the parents lack the capacity to implement those other means.
Correct. I think she addressed the mother's underlying not underlying, it was a major factor in the case, mother's untreated mental health. So I think given mother's untreated mental health and the findings related to those, I think those incorporated in the ultimate finding of that mother was incapable of supporting my client in any harm suffered. But I would also suggest that my client is with paternal grandparents. This isn't a case where we have non-kinship foster parents who are looking to adopt him. These are his natural relatives. It's a natural bond. I don't know that you need expert testimony on whether a grandparent is naturally bonded to a grandchild. I don't have that answer for Your Honor. As to the delay in this case and that it prejudiced mother to the extent that it required reversal, it's simply not the case here. Case law suggests that even greater delays, such as in Dawn, where the parents argued that a delay from initial to 5 years later, concluding the trial, was not egregious enough to warrant reversal. Also, in addition, the delay here was not the single factor in this matter. Mother's own inabilities and inactions contributed to the delay. I think you can look at, counsel would suggest that it was the passage of time, but I would also suggest that it gave mother an opportunity, much like prior to a review and redetermination, to make some positive changes after an adjudication. But mother did not do so. She failed to sign a release for the psychological examination. She refused.
Counsel, doesn't that go to exactly opposing counsel's point of the due process violation, that there was no notice? As far as mom was concerned, the trial was over. Any decision that the judge was going to make, she had already had all the evidence. So anything she would do afterwards wouldn't have anything to do with the judge's decision.
Correct, but I agree with Your Honors that the proper remedy would be to file a motion for a request for findings, a motion for clarification, or a motion for a decision. There's lots of different mechanisms to file a motion post-trial. These delays are constant, unfortunately.
But in a situation where a judge is, I'll say repeatedly, I won't say constantly, but repeatedly saying, I'm going to get you my findings, I'm going to get you my findings, what would filing a motion do? She's already said, I'm going to get you the findings.
The suggestion would be that you could then take that to a single justice, that the denial of a motion for findings is an appealable event, that mother could then appeal from that, the lack of findings. But I would also suggest that care and protections in their nature are ever-changing. They're not stagnant. So mother's condition at the last day of trial could change the following week with a positive drug test, could change the following week with participation in any of the services.
Maybe you knew this was coming because I've asked him and I've asked her, and now I'm going to ask you based on that exact statement.
Yes.
What factors is a judge supposed to use to decide whether allowing a motion to reopen evidence? Based on what you just told me, one thing that mom does positively after the trial ends, she could file a motion to reopen the evidence.
I wouldn't suggest a motion to reopen in that instance. I was talking about the statutory review and redetermination. So if you get a decision that terminates your parental rights, your review is appeal. If you get a decision that just adjudicates you in need of care and protection but doesn't terminate, the mother can still come back. You know, the child remains in care, mother can still, or father can still come back in 6 months on a motion. You still have to file a motion for review and redetermination. But reopening, I believe I found a case, it's LL versus Commonwealth, I believe, and I think that's the reopening of evidence case that would suggest.
That's within minutes or a few hours, correct, that case? The Commonwealth asked to reopen the evidence after she had closed and asks almost immediately, oh, I forgot something, can I reopen the evidence? This is a little different than that, and I am trying to figure out, I'm from a world where once the evidence is closed, it's closed. So what, and we're looking at an abuse of discretion. What's a judge supposed to use to decide whether he or she will allow a reopening of evidence? And I really haven't gotten an answer.
I understand that, and I equally would agree with you. I would certainly, you know, the rules of civil procedure generally apply to these cases, but I would look to other practices, you know, a criminal practice and what you measure to reopen. I think the remedy here would have been objection. Objection at the time and written objection. I see I'm out of time. Thank you.
Thank you. Thank you all. Our final case for today is 22P734, DF Prey Incorporated versus Westco Insurance. Mr. Briansky, and before we start and before the clock starts, I want to say, please, the next time you take an appeal on an insurance coverage case, include the policy in your record appendix and give us cites to it when you're talking about the policy provisions. It makes it very difficult to follow.
I apologize, Your Honor. May it please the Court, Richard Briansky on behalf of DF Prey. This appeal involves a very limited and discrete due process challenge to the Court's entry of summary judgment on an issue raised sui sponte by the Court without notice.
So I'm not seeing Westco really defend the judge's rationale. It's up to you to decide how to spend your time, but Westco has raised some seemingly significant issues about personal jurisdiction and about coverage apart from whether Prey knew that the work was, you know, that Extreme wasn't doing a good job before Extreme failed to put these extra layers of drywall on. So maybe you want to address those issues.
No, I appreciate that, Your Honor, and I'll get to those underlying, first, the personal jurisdiction issue, which I'll address. And Your Honor, we had suggested in the brief, and I'll reiterate here, that issue, we believe, was waived. It was raised on an issue for motion for summary judgment. I mean, strike that, on a motion to dismiss. But it was not raised thereafter. And in fact, what Westco did through its actions,
Why would it have to be raised thereafter? I mean, Westco moved to dismiss on personal jurisdiction grounds. That was denied. Does Westco have to keep banging its head against the wall at every subsequent motion in order to preserve that?
No, Your Honor, but what I would suggest is the following. They did invoke the Court's jurisdiction by submitting counterclaims.
Those counterclaims are purely declarations that are essentially defenses. A declaration that the grounds for which you claim coverage are not applicable.
That's fair enough, Your Honor, but then they move for summary judgment, and when they move for summary judgment, they're asking the Court to make a determination as a matter of law on their particular claims. Again, they're invoking the Court's jurisdiction without raising the issue of personal jurisdiction. If there's not a waiver, that has to be.
They did raise it. They raised it in their motion to dismiss.
They did raise it in the motion to dismiss, but they didn't subsequently raise it on a motion for summary judgment.
Why were they required to raise it again on summary judgment?
Because they're actually asking the court to invoke jurisdiction to give them a judgment.
Well, sorry.
A judgment that would be no better than a dismissal for lack of jurisdiction. They're not asking the court for anything more favorable.
Well, I guess that's fair enough, Your Honor, but if they don't invoke it, and they're asking, well, I guess I understand what you're saying, but to me, there was a real problem with the failure to raise that on a motion for summary judgment. And why wouldn't they raise it if it was a real issue? And instead, they're going to rely on this particular judgment. I can't imagine
unless there are new facts that were developed through discovery, I don't see why they would have to raise the same argument that's already been denied on the motion to dismiss.
When they're asking the court to basically invoke its jurisdiction to make a judgment in its favor? I mean, why wouldn't they rewrite?
What are they supposed to do? So their motion to dismiss is denied. They can't appeal that right away, right?
That's correct.
They have to wait for the judgment. I mean, what are they supposed to do? So they just keep re-raising the same argument every time they're filing something?
Not re-raising it, Your Honor. I didn't make that suggestion. My suggestion was when you're moving for summary judgment, you're asking the court to make a determination as a matter of law, you're invoking the court's jurisdiction. And I think that's inherently inconsistent with claiming the court doesn't have personal jurisdiction, and I think there's an obligation to raise it. That's not repetitious. It's asking after the evidence has been completed and after discovery is completed for judgment as a matter of law, and it wasn't raised at all, and in fact, just the opposite. They asked the court to enter judgment. Isn't that asking the court to assume jurisdiction over them? Don't they want this judgment to be binding? And how is that not a waiver? How is that completely inconsistent with their argument that the court lacks jurisdiction over them? And I guess I go back to what is the prejudice of asserting it and to make sure that it's preserved for appeal? You've only raised it on a motion to dismiss. You know, there could have been subsequent reasons that they wanted the judgment. They want to waive it. I don't understand how that behavior, and I get what you're saying, they raised it initially, but I'm not saying they have to bang the court over the head either.
What's that? Sorry, I didn't hear it because of the noise outside.
Sorry.
What did you just say?
I was saying they don't have to bang the court over the head either. I don't understand how they can't raise it on a motion for summary judgment.
So it would have been sufficient to drop a footnote in their motion saying, by the way, we press our personal jurisdiction argument, but nothing's changed. We think the court was wrong, but if the court's not inclined to revisit that, then please resolve our motion for summary judgment. Is that enough?
That's enough, Your Honor. And if you read the judge's decision, which I'm sure you did, it was part of the record, he invited them to bring this again at summary judgment.
Well, he invited, when he said without prejudice, that was denying the motion to dismiss on the merits. There was nothing in the motion judge's discussion of personal jurisdiction I saw that addressed the further factual development or further legal argument.
But there was certainly nothing to preclude Westco from raising this personal jurisdiction.
Oh, but they had nothing new to say.
Well, but that's fair. But dropping the note at least preserves it for the court. They're still taking that same consistent position that the court lacks jurisdiction. And to the extent the court were to conclude that it had jurisdiction, then it could reach the merits of the claim. But isn't that essentially what the court did here? Didn't the court reach the merits of the claim and make a conclusion as a matter of law based on the policy that there was no coverage? And how can you have the court make a conclusion as a matter of law and then say there's no personal jurisdiction? What impact does that have on the decision that was issued by the judge? It would be a nullity under your circumstance. And all I'm suggesting is that if you're going to do that, that seems to me inherently consistent with, and I've now been repetitious, but I don't think I can help myself, but it seems inconsistent with asking the judge to issue an order. So if you're correct, and if they're correct, then the case gets dismissed. There really hasn't been a decision as a matter of law, and can we refile the claim? Do we get to relitigate it again in the proper jurisdiction where there's personal jurisdiction over Westco? Don't you think they'd be satisfied now after we spent the Commonwealth's money litigating the case in this particular form and we got a decision on the merits, interpreting the plain language of the policy, that that's something that's going to be binding, that Westco wants it to be binding? We were actually sort of surprised that they raised that issue, given that they asked for a merits determination. In fact, that's exactly what they got, a merits determination by the judge. She interpreted the policy of insurance that they issued, and she happened to interpret it favorably to WESCO.
The case that you cite from the SJC, I was looking for American Insurance Company. It says, and I just lost it again. Parties who opt to raise such a defense, meaning lack of personal jurisdiction, in a responsive pleading may ensure its preservation by moving to dismiss pursuant to Rule 12b-2 within a reasonable time prior to substantially participating in discovery and litigating the merits of the case. Isn't that what happened here?
That's correct.
So,
But that's not it. You can, and this is my argument, which I think is separate and apart from what you're saying, Your Honor. That's all right when challenging the court's personal jurisdiction is something that can be waived.
right.
And when you ask, and I don't disagree with what you just said. In fact, we cited it in our brief. But when you take subsequent conduct, which is inconsistent with the position that you took, like here, when you ask the courts to issue a merits decision on interpreting the insurance
Can they
policy,
defend against a summary judgment motion without waiving the defense? I mean, what can't they do after their motion to dismiss is denied?
I thought Your Honor, all I was suggesting is they need to continue to preserve that defense before they ask for a merits determination.
Do you have any case law to support that? I mean, I think what Judge Shin just cited supports the fact that once you raise it in a motion to dismiss, that right is preserved for appeal, period.
Well, I guess I disagree with that because that's taking, and I don't disagree with the initial statement, but if you take, I think there's plenty of case law that we cited on waiver, and I don't think there's anything unusual about what I'm saying here, and I think there's a material distinction to be made between raising the defense at initial motion to dismiss stage and then subsequently asking the court to invoke its jurisdiction and make a merits determination on a motion for summary judgment. I would suggest to you that there's probably no case where there's a preservation. I don't know, so I'm not going to overstate. But to the extent that was an issue for the court, we could certainly provide additional research.
Can I ask a question about where something is in the record, which bears on personal jurisdiction? Where is the schedule that shows Prey as an additional insured? I see the endorsements that talk about, whoever is on the schedule is an additional insured, but I don't see the schedule.
I wouldn't be able to identify that for you right here, Your Honor.
Is it there?
I don't know, Your Honor, and I don't want to misrepresent anything to the court. But I don't think that's a disputed issue of fact at all, that Prey's an additional insured.
So
But the terms of that and how, the foreseeability to Westco of Prey being an additional insured, Prey being with a principal place of business in Massachusetts, that seems to me relevant to the personal jurisdiction issue.
Yeah, but I don't think that was ever disputed. And I guess you're saying you need evidence of it, but Westco's not claiming.
Not that they were listed, but, what the schedule says and whether that schedule ever comes to Westco's attention, or whether Westco is just writing a blank check by putting these endorsements on there that says whoever Extreme lists on the schedule is an additional insured, that seems relevant to foreseeability of being hailed into court in Massachusetts.
Well, I don't disagree with Your Honor, but that would have to do with the entire process of how that additional insured was identified and whether Westco, because Westco's never objected that Prey is an additional insured. So however that process were to operate, whether it's by discretion of the insured putting the additional insured on or by Westco approving it, there's some policy or practice at Westco that exists that allows that sort of discretion, either by the insured or by Westco. So it's contractual by nature, and it certainly was never issued. If you look and review the record, there's certainly no indication in the record that Westco's objecting to Prey's status as the additional insured.
Well, they may agree that they're an additional insured. And my question is, does that mean that anyone is covered under this policy and can be sued in Massachusetts because of the term additional insured?
Does that mean anyone can be sued in Massachusetts?
Yeah.
I mean, Well, the way I look at this, Your Honor, is that to the extent Westco wanted to restrict jurisdiction, they were perfectly capable of doing that in their policy of insurance.
I get that.
And they didn't.
I'm asking you a pretty direct question.
Right.
Does that mean that anyone can be sued in Massachusetts because the policy says additional insured?
If they're a Massachusetts resident, I think it's reasonably foreseeable, if that's a risk that you're covering, that they would be sued in Massachusetts, especially here where the underlying subcontract, which presumably was available to Westco, had a venue provision which identified Massachusetts. And it's not like Westco doesn't do business here. They have at least 100 agents. They do $30 million worth of business here. There's certainly that connection here. They file lawsuits here, which we identified, which the court relied upon in its ruling on the motion to dismiss. This certainly isn't a hardship, especially to an insurance company that essentially does work nationwide, that they'll be sued in a particular state where they have issued a policy to an additional insured. And like I said, and I don't need to repeat myself, I guess.
Supplemental Record Appendix 104 is an endorsement. Additional insured, owners, lessees, or contractors, automatic status when required in construction agreement with you. You, I suppose, meaning Prey in that circumstance. Does that endorsement apply here?
I believe it does, Your Honor, but I don't have it in front of me, and I don't want to misrepresent anything, and I'm concerned about taking a position without looking at it. So I hadn't looked at that particular provision.
Okay. Is there a majority rule on whether rip and tear damage is an occurrence?
When you say majority rule, you're talking about states?
Yes.
I relied heavily on the Gray construction case, and one of the reasons, it's a 10th Circuit case, but one of the reasons I like that case and I felt it was particularly compelling is because the essential survey of the law that the 10th Circuit did before they made their conclusions and their reliance on the plain language of the policy. I think it was really compelling to me. Not only was it compelling to me, but the court cited it in its decision on summary judgment, and they indicated that there was a prevailing trend. I'm not quite sure they used the word majority decision, but they relied on the 1986 amendment to the policy, which takes an express exclusion. It recognizes the potential coverage for subcontractor claims, and they relied on that plain language to find that this type of damage would be anticipated, and it was an amendment from the prior.
Well, you say this type of damage, and when I read the citations in your brief, it seems like those cases are talking about situations where the subcontractor's work itself causes damage to some other parts of the property. So for instance, faulty pipes cause water damage to some other part of the property. That's not what happened here. The Extreme's failure to install the 3 layers of drywall did not itself cause damage to any other part of the property, right? So do you have a case that rises in this factual context?
I don't know if I have this particular factual context, but this type of rip and tear damage has been recognized, and we cited.
No, but it's different. It's when it's a different situation where the work causes damage, say like water damage or foundation damage to the foundation, collapsed ceiling. Those are the cases that you're relying on. But the factual situation here is not that it caused damage, it's the cost to repair the faulty work.
Well, that's not true.
Okay.
Well, let me just take that a step back. What the court found that I thought was particularly compelling and consistent with the argument we make is that this was potential to cause damage. Basically, did we have to wait for the fire to ignite? And to your point, had the fire ignited and this particular system didn't work as it was intended to, that would have caused the damage that you're talking about. And what we argued in the brief and what the judge accepted in her decision was that type of potential exposure would be covered under the policy. That is
Is there a case that talks about potential damage to other property?
I think I got this from a case, but I can't tell you right now where I specifically cited to, but if you would like me to afterwards, I can certainly supplement. Thank you.
I want to ask one clarifying question. Westco has talked about the exclusions, J6 and M in particular, both of which use the phrase, your work. And when we evaluate those exclusions and think about what your work there means, you're claiming, Prey is claiming here as an insured primarily, not as an additional insured, not because of Extreme's liability to you, but direct liability of the insurer, correct?
I think they're both, so, and I would.
They may be both in the case, but.
Yeah, no, I just wanted to take a step back so I think I can properly answer your question. If you look at your work exclusion, it has a specific exception for subcontractor work. And that, when you apply that exception to those two exclusions, you'll find, at least it was my interpretation based on the policy, that they're really talking about the defective work, because that's what those business risk exclusions are intended to prevent, coverage for defective work, not coverage that we're seeking here for non-defective work that was required to be destroyed as a result of the defective work.
So the exclusions in turn have specific exclusions for subcontractors?
There is, and I'll identify it for you, Your Honor. It's, if you look at, bear with me 1 second, because I thought, yeah, if you look at exclusion 2, and I think it's 2L, damage to your work, it says this exclusion does not apply if the damaged work or the work out of which the damage arises was performed on your behalf by a subcontractor.
What page are you on?
I was actually just reading from the judge's decision.
SRA
It's 31 of the appendix.
Sorry, 45.
But she's quoting from the policy language.
But the phrase, this exclusion in exclusion L doesn't carry over to exclusion M or exclusion J6 as far as I can tell.
Well, they're talking, well, both, I thought exclusion M and exclusion J were talking about particular defective work. And we're not seeking coverage for particular defective work.
All right.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors.
Mr.
Court.
Gershwire?
Gershwire.
Gershwire.
Max Gershwire for Westco. I wanted to address a couple of the questions that Your Honors had about aspects of the policy. Number one, there is no endorsement that specifically identifies PRE as an additional insured. They qualify as an additional insured through the blanket additional insured endorsements that simply say that anyone who Extreme is required by written contract to include on the policy qualifies as an additional insured, subject to certain limitations.
So, therefore, it's the, is that the endorsement that I was asking counsel about?
That's correct, Judge, if it's the one I was thinking of.
Okay, so isn't Westco then writing kind of a blank check to Extreme? Say, we'll insure, meaning we'll indemnify and defend anyone that you have entered into a contract with that we may not know about to be a sub for. I mean, it makes it foreseeable that anyone with whom PRE, for whom PRE is a subcontractor, is someone to whom you're going to be required to indemnify and defend. And, you know, here we are in a general contractor in a neighboring state. How is that unforeseeable?
Well, Judge, I would submit that the question of foreseeability is not dispositive. The question is not only whether it would be foreseeable, the question is whether the contact between Westco and Massachusetts, whether the claim at issue arises out of that contact, whatever contact there may be.
Are we talking about under the due process clause?
Well, we can start with
under the long-arm statute. I guess I'm confused about your argument under the long-arm statute. So it applies if you contract to insure any person located within the Commonwealth.
Correct.
Why doesn't that apply?
Because Westco did not contract with PRE. It contracted with Extreme. It also says, if you read the whole subsection, contracting to insure any person within the Commonwealth at the time of contract.
But if,
so in other words, it's quite possible, for example, here or another circumstance where you have well, first of all, PRE was obviously not known to Westco when the policy was issued, right? They're not identified on the policy. You can certainly have I would submit that the phrase at the time of contracting and contracted to insure any person refers to the actual insured to whom the policy is issued, not some party unknown to the insurer who may later qualify as an additional insured based on a contract that Extreme, the named insured, not Wesco,
We're supposed to read the long-arm statute broadly, right?
Yes, Your Honor,
Okay.
but I would still submit that the language indicates that it's the actual party or parties that the insurer is directly contracting with at the time of contracting to insure. But even assuming that that's not the case, even if you read it broader, the beginning of the long-arm statute still requires that the cause of action must arise from any of the following subsections. So I would submit that while perhaps the Wesco policy, by potentially covering a claim in any state, potentially covering an additional insured unknown to it in any state, may give rise to a certain level of foreseeability, but the claim still has to arise out of that contact. When you have a claim like this one that does not arise out of an incident that occurs within the Commonwealth, it lacks the necessary connection between the foreseeability that you're speaking of and the actual cause of action at issue. There has to be that connection. But in any event, under federal due process, and I cite this, the Lexington insurance case from the Seventh Circuit, that's quite similar to, factually to this one. The court makes a point of saying that under federal due process, the idea of foreseeability is not dispositive or even particularly weighty in determining whether there's personal jurisdiction. And in that case, the court found under, again, almost identical circumstances, it found that this was a policy that was issued to a party that was not within Wisconsin. They happened to additionally insure a party that was in Wisconsin, but the incident did not occur in Wisconsin. There was no litigation in Wisconsin that required the insurer to supply the services, in other words, defense and indemnity, that it contracted to perform. Same thing is here. There was no suit against Prey in the Commonwealth that required Wesco to come in and supply the services that it contracted to provide.
There's one major factual difference with the Seventh Circuit case that I saw, which is there the defendants were Taiwanese insurers, right? And they did no business whatsoever in Wisconsin. They had no context whatsoever with Wisconsin. Isn't that relevant to a due process analysis?
Not for specific jurisdiction.
Yeah, I didn't understand that argument. Why don't we consider generally the contacts that the defendant has with the forum, which is what I thought we're supposed to look at?
There's the difference between general jurisdiction and specific jurisdiction.
Right, I understand that.
So the contacts, for example, the fact that Wesco has agents who have offices in Massachusetts, the fact that it does a certain amount of business in Massachusetts, the fact that it's a licensed insurer in Massachusetts, all of that is relevant only to general jurisdiction. There is no argument here that the contacts here are sufficient to establish.
International Shoe and Worldwide Volkswagen, they both look to general context with the forum in a specific jurisdiction analysis.
I didn't review those cases for this case. I probably don't remember it from law school well enough. But when it comes to specific jurisdiction, the key question in specific jurisdiction is, are the defendant's contacts with the forum, do they relate to the claim being made?
Isn't that a separate factor under due process analysis? That goes to the nexus requirement. But aren't we talking, when we look at purposeful availment, don't we look at all of the contacts with the forum?
I don't believe in the context of specific jurisdiction. That's correct, Judge. It's only the contacts that relate to the specific claim. So if Wesco issues policies in Massachusetts to Massachusetts insureds, that would be relevant only if this was one of those policies.
How is that separate from the nexus requirement? How would purposeful availment then be different from the requirement that there be a nexus between the context and the claim?
They're related, I believe, Judge. There are different kinds of contacts that the judges look at depending upon whether you're arguing general or specific jurisdiction. For specific, it's only the contacts that relate to the claim at issue, not to those that are unrelated.
Do
In fact,
you have a case that says that?
the Seventh Circuit case that I cite talks about that. In fact, I think I quoted something to that effect in my brief from that case. I'd have to take a look at it, but.
I mean, the Seventh Circuit case says it is a defendant's contacts with the forum state, not with the plaintiff, that count.
That's correct. Right, but the contacts still have to relate to the specific claim at issue. They can't be contacts.
How does that
have
relate?
nothing
How
to
does
do-
that not relate to the plaintiff as opposed to the forum state? They're saying you look at the contacts with the forum state, not the specific plaintiff. I think the issue in the Seventh Circuit case was that there were simply no contacts whatsoever with the forum state.
I believe that the court looked at whether they looked specifically at the contacts in the context of the policy at issue. I don't believe that it had anything to do with the fact that, or at least with regard to specific jurisdiction, had anything to do with the fact that, because the court keeps talking about how the insurer did not have any contact with the additional insured in the context of the claim, didn't receive any premium for this particular policy. So I believe, Judge, that the decision is quite clear that the only relevant contacts are those that relate to the claims at issue.
Can I ask a few questions about the merits?
Sure.
So, if we get there. So first of all, you don't seem to defend the particular rationale adopted by the motion judge. Is that correct?
That's correct, Judge.
Okay. I asked Prey this question. I'll ask you. Exclusions J6 and M use the phrase "your work."
Yes.
As we read those and think about D.F. Prey's work, I mean, your work is. Should we be thinking about Extreme's work there as well?
In fact, Judge, you should only be thinking about Extreme's work. The words "you" and "your" are defined in the policy to refer only to the named insured, not to the additional insured.
But your work is defined as you or anyone doing work on your behalf? Let me just find the definitions.
Yes, Judge, but first you need to look at the definition of "you" and "your," which is on the first page of the commercial general liability form. It defines "you" and "your" to mean only the named insured, not an additional insured.
So that is on page what of?
I'll tell you in a second here. It should be on supplemental appendix page 41. I believe that's the first page of the base CGL form.
Okay, so then when we read those exclusions, we should be thinking only about Extreme's work.
That's correct. If there had been subcontractors working for Extreme, you'd look at those subcontractors' work as well, but that's not the case here.
J6 applies to part of any property that must be restored, repaired, or replaced because your, i.e. Extreme's work,
Correct.
was incorrectly performed on it. So that doesn't encompass rip and tear damages to other parts of the property, right?
Well, yes and no.
Okay.
Obviously, our argument is that per a lot of, number of cases that we've cited, including from a New York court and a Superior Court in the Commonwealth, is that rip and tear damage is part and parcel of the cost to repair or replace the named insured's own faulty workmanship, which all parties concede is not covered. So the argument there is that, the courts pretty much nationwide, including New York and Massachusetts, draw a line between faulty workmanship and damage or injury that is caused to other property or people by that faulty workmanship. again, the former, there's no dispute that that's not covered. So the question becomes, well, first of all, and this case is a perfect example, the fact that Extreme put in one layer of drywall as opposed to 3 clearly did not damage any other property. So this is, and Justice Shin, I think you were getting at this before. So there is no other property damage here. The rip and tear damage is not, in fact, property damage in the sense that it's damage caused by the faulty workmanship, which is not covered. It's simply the inherent cost, the foreseeable cost of having to repair what is indisputably not covered, which is the faulty workmanship of Extreme. So that's been the foundation for the courts that have, the majority of the courts that have addressed the issue that have found that rip and tear is not covered, precisely because it is so tied up in simply the cost to repair what is clearly not covered, which is the faulty workmanship, that the courts deem it to be part and parcel of the same thing.
I don't mean to repeat Justice Shin's question, but I want to focus again on the words "and on it" in exclusion J6. Just take plumbing fixtures, for example, that had to be torn out and eventually replaced in order to get access to the shaft to repair Extreme's work. How does that exclusion apply here where Extreme never did any work on plumbing fixtures? So J6 excludes damage to that particular part of property that must be restored, repaired, or replaced because your work was incorrectly performed on it.
Right. Well, Judge, I would preface my response by first saying our position is that you don't even get to the exclusions.
But you rely on them as an alternative or backup argument, so.
Right. Well, again, I mean, yes, the particular part here would not be the fixtures and anything else apart from the Extreme's own work. But again, this goes back to the idea that, well, but if the cost to replace or repair the faulty workmanship itself, the drywall, is not covered, then anything that has to do with replacing or repairing it would fall within that same category. So, of course, I'm not saying that Extreme worked on that other property that you're referring to, but again, they're so inextricably entwined that the argument is that it all falls within the insured's own faulty workmanship, and of course that doesn't address the impaired property exclusion, which is another basis for our position that there's no coverage.
So, sorry, I have just one more question. On the whether this qualifies as an occurrence, do you have a response to the argument that it could be potential property damage and is therefore covered as an occurrence?
Yeah, the only cases that one might see that have to do with the potential for damage are ones where it's imminent, that there's an imminent and direct possibility of damage to other property. I cite a case from New York, a New York Appellate Division case that stands for that proposition. So that's clearly not the case here. And I'd also point you to the Arizona case that I cite in the brief that talks about, and I think this is very revealing because it talks about certain damage being covered and certain not being covered. It found that rip and tear damage is not covered, but it found, I think, that there was a small slice of damage that was because it was so imminent, the possibility of damage to the property was so imminent that piece would be covered. We don't have that here. The only potential for damage would be if at some point in time there was a fire that the absence of the extra drywall might result in more damage. Clearly that was not an imminent situation, so that would not apply here.
Okay. Anything further? Okay. I did have a bone to pick with Westco's brief as well, which is that on page 13 you quote sections from the policy about who is an insured in two places, and you talk about only with respect to liability for bodily injury. And there's an ellipsis, And we have to go to the record appendix to see that the ellipsis refers to property damage, which is obviously the central issue here.
I apologize, Judge.
Try not to do it again.
Thank you.
All right, with that, I want to thanks our court staff for